mentioned?
Delivery order first. Delivery order AB 641 of 2026 with AB 864 of 2026. Yeah, please.
The bail petition of the wife is allowed, but the other one is not allowed. Some trails are there. Yes.
Wait, please, Lordship, it's a joint prayer in respect of item number 57 and 58 of supplementary list, my lord.
57?
57 and 58, they're tagged together.
Okay.
My lord, this matter may be adjourned for the day, my lord. Maybe
After vacation.
after vacation, my lord. Maybe in the first week of August, my lord.
Achha, first week of August.
Lordship, I am for the response number 3 in 57, Lordship. Can you fix it on 4th of August, Lordship?
Learned Council, joint prayer is made on behalf of the both the sides for adjourning the matter, posting it on 4th August. The prayer is allowed. This is the matters on 4/8/2026. Any interim order is there?
Yes, my lord, that will be continued.
In both the petitions?
In both the petition, they are
Interim order dated, might be, or interim order might be different dates, no? In the
on different dates.
I'd so and so date, stays extended to next order list.
Shall be continued.
Shall be continued to the next.
Obliged.
Please don't.
Like,
Item number 64, my lord. It was last listed on 23, my lord, then
Mm.
yesterday also, my lord, but not reached, my lord.
Okay.
May I pray for my lord, such like accommodation, my lord, at 2 PM, my lord.
No, I'll finish everything.
Wait, please, Your Lordship. I beg to mention item number 20.
20.
Here I am for the response number 2. We have taken consent of the other side. It may be listed after vacation.
Item 20.
20.
Staple might even. Criminal appeal. Has it been admitted? No, not admitted. Not admitted. Should I admit it then?
My lord, I have to take instructions.
It can be admitted anyway, as you wish. Perhaps save some time. Anyway, Learned Council, on the prayer of the Learned Council for the appellate, he's not in jail, no?
No, my lord, I am for the respondent.
You're for the respondent. You have taken consent of the other side first. The Learned Council for the respondent number 2 submits that with the consent of the Learned Council for the appellant. He is seeking an accommodation and prays for listing the appeal after the break. After the break. So list on, you can suggest a date also.
Any date, my lord.
List on 24.
My lord.
24/7. 24/7.
May it please your
Obliged.
lordship. May it please your lordship.
Yes, ma'am.
Lordship, I think to mention item 34, lordship. Here, here in this case, lordship, senior advocate Kiran Chaudhary sir has been engaged. He has instructed me to place before this court to make a prayer, so then matter may be taken up at 2 PM, lordship.
So we'll adjust the accommodation.
Lordship,
We'll
I'm
adjust.
obliged.
If not 2, we'll adjust. I finish all the matters. All the no listed matter will be left. We'll touch everything.
That is a lordship. I beg to mention item number 24 of the daily list.
24.
If we fix after vacation.
L. Banik, Learned Counsel for the petition. Praise for posting the matter after the vacation. Scan record is available. List. You can suggest a date.
20 July.
20 July.
may I please, Your Lordship, I beg to mention item number 38.
38.
38.
38.
Seek for some accommodation for the day, Lordship. Can it be listed after vacation?
Case diary is received.
Yes, it is.
That's the problem then. Case diary. You have an interim order.
Lordship.
Then. But case diary is received now.
If they can,
38.
okay, we'll send if they can get it updated also.
The on the prayer of the Learned Council for the petitioner, the matter may be posted after the break. However, the case diary has been received. The learned additional PP submits that he shall in the meantime get the case diary updated first. The case diary may be returned and procured again with the up-to-date investigation for the next day. List on after vacation, right? 17?
70. Actually, interim may kindly be
Interim order by so and so stands extended till next date of list.
deeply obliged.
May I please, Your Lordship? I beg to mention for item number 46, Lordship.
46,
Kindly, I may be allowed to withdraw this.
withdraw. There's a listed withdrawal also. Yes. You are Mr. Khan.
Naikam.
Anakhan. Learned counsel for the petitioner submits that he has instructions to seek withdrawal of the bail petition. Prayer is allowed, disposed upon withdrawal. Okay.
May I please your, may I please your lordship?
Yes.
I beg to mention item number 19,
19,
198. Lordship, kindly matter may be adjourned for the days.
you are for the petitioner side. NCB is the, you are there.
For another matter.
Kindly inform them if you haven't. Petitioner, learned counsel, the petitioner seeks an accommodation, prays for posting the matter after the vacation. List on any specified date?
It's
28/7. 28/7. Any interim order? Interim order is there? Not sure. We'll check it. Check it.
May I please your lordship?
Yes.
Lordship, I beg to mention item number 28. Lordship, in this matter, we have filed our objection yesterday, but it is not in the record. The objection may be called for.
Objection will be called.
May I please your lordship? Lordship, I beg to mention item number 39 of today's list, lordship.
Okay.
I have instruction from the client not to press the application.
You want to withdraw?
Lordship.
Mr. U. Chaudhary, learned counsel, prays for withdrawing this bail petition, comma, which is allowed. The bail petition stands disposed of upon withdrawal.
Oblige your lordship.
May I please, your lordship? Item number 37. The youngest counsel, Mr. Jadalam, is having some personal difficulties. And as such, the matter may be adjourned to the.
There's a private respondent counsel. Kindly inform her. Ms. Nazneen.
Yes.
Respond number 2. Scan record is a learned counsel for seeks an adjournment due to the personal difficulty of the leading counsel. J. Dalam, full stop. Scan record is available. Full stop. List the matter on 29/7. 29/7. Any interim order is there?
No.
No.
May I please your lordship? I beg to mention item 41, lordship. Matter may be taken after vacation.
41, I have a blank.
Wrongly listed.
I have a blank here. Blank in the top list.
The order matter, criminal appeal.
Oh, wrongly listed. Wrongly listed. Do not bother. Yes.
May I please, Your Lordship? I beg to mention 20 onward, item number
21.
list. May kindly please tell it that after vacation.
It's part heard. Part heard
hard.
matter. After vacation.
After vacation time.
Learned
27, 28,
You're Mr.
that from my lordship.
J. Rahman, learned counsel, prays for listing the matter after the vacation.
My lord, here, although it is
After the break.
my lord, although it is causally, it was shown as part heart matter.
But it's not mentioned as
But
part heard.
not in the.
Full stop. It is pointed out by Mr. Sharma, learned additional PP that the order, it is not mentioned as
My lord.
part heard, though indicated as so in the cause list, full stop. The matter may not be shown as
My lord.
part heard in the cause list, full stop. List the matter on, you can suggest a date,
27, 28, when is it?
27.
I'll leave it.
Wait, please, Lordship. Lordship, I beg to mention item number 63 of supplementary this panel. Hereby we have taken steps and office note dated 23/6/26 shows that our service report is awaited.
Mhm.
So the matter may kindly be adjusted, madam.
After the
Yes, madam. And there is an interim order, madam.
May Chaudhary, learned counsel for the petitioner submits that those steps have been taken upon respond number 2, comma, service report is awaited. Full stop. List the matter after 3 weeks,
After change.
after 3 weeks on a we can fix a date. I think. 31st July,
Madam,
31/7. The interim order of so and so stands extended till next date of listing.
deeply obliged, madam.
I also. Withdraw.
The item of A.
Report 850 application, Lordship petitioner was arrested on 9/6/2026. Lordship will find the FIR at page number 15. May I read the FIR, my lord?
Not necessary, it's
My lord,
from,
only my allegation will find at page number 16. That's third paragraph, Lordship.
let's get the case diary.
My lord, kindly see the allegation that from my position, nothing was recovered. At paragraph number third paragraph, Lordship. One person arrested from his position 6.3 gram suspected heroin and
Where? Page 16.
page 16, Lordship. Page 16, Lordship, paragraph number 3.
Mhm.
On spot interrogation of the accused Rakibur Rahman, he admitted that he has purchased the said quantity of drugs from one person of Mori Morsalim Gaon, namely Mofidul Hassan. This is the petition. He also revealed that he is a regular purchaser of drugs from him. Yesterday also he purchased lesser quantity from that particular person. Today he has purchased heroin amounting of rupees 30,000. Accordingly, acting upon his input, the team conducted raid, searched at the house of Mofidul Hassan in presence of local witnesses and recovered of sum of rupees 40,970 and seized the same in presence of witness by preparing a separate seizure list. This is the only allegation against me, madam.
What is his name? Mofidul Islam.
Yes. From my position, nothing was recovered, only 40,970 rupees recovered and in presence of the witness, only on the basis of the earlier arrested accused.
No,
person.
because the allegation is that, okay, anyway.
My lord, let me finish. They have to produce this document that they have to show the relationship between the accused and this person also.
His name immersed
Regarding 27A, my lord. There is nothing in the FIR, my lord, that he is
financing, yeah. Diary would be necessary.
Madam,
Diary would be necessary, obviously.
in that case, lordship may fix the matter during vacation, my lord, on second lord.
Why so? This is a
My lord, because there is
drugs
nothing.
matter,
My lord, there is nothing.
He's the main accused, actually, that he's a regular purchaser from this Mafidul Hassan only. He's supposed to be the main accused.
My lord,
What are the other dates? What are the other dates?
second is there, 30 is there, 9, 7 is there, my lord.
Full stop. Just write third and learned counsel for the petitioner. Call for the case diaries of Morigaon PS case number 87 of 2026. This is the matter on 9/7.
Obliged, my lord.
Say बोले question. Nine, 9/7.
Okay.
You sure, no, about the dates?
Yes, yes.
32,
7 and 9.
7 and 9. 32, 7 and 9. No problem. 30 and 2 I know.
Already the notification.
My lord, notification is there, lordship, with me.
No,
my
no,
lord.
30 and 2 I know because
My lord,
I've
notification.
been given. So
My lord, let me check, lordship.
no, it's okay, don't worry. It must be.
Would you at 45?
9. It's there, no?
My lord, 7, 9, it's second and 30.
Second and 30 I know.
Can be a 9, 7, lordship.
Give it
7, lordship.
7. Make it 7.
Lordship, obliged to lordship.
Withdraw.
I beg to withdraw this matter with liberty to file a fresh.
Mr. Bormia, learned counsel for the petitioner submits that he may be allowed to withdraw this bail petition, however, with a liberty to file a
Criminal petition.
criminal petition, however, with a liberty to file a fresh one. There's some defects there.
Yes, madam. Some documents
Stop.
to it.
It is submitted that some defects had crept in, for which this step is having to be taken. The prayer is allowed. The criminal petition is disposed of on withdrawal, however, with a liberty to file a fresh one.
Keep problem.
Number 4.
Commercial quantity. My lord, in this case, my lord, another my lord bail matter out of the same.
Just a
21 to 530.
order लिखा है ना? Corrected. Sorry.
My lord, another bail application out of the same, my lord, the PS case is fixed on my lord the 13th of my lord coming my lord July. My lord. So my lord, this
Yeah.
matter may be also posted.
4, item 4.
Yes, my lord.
पार्ट भी लिखा नहीं
Yeah.
conclusive
But
হয়েছে।
it is non-inclusive.
Conclusive guide করে দেব হয়তো লিখে দিলে হবে না এটা। It is Mr. Borbia, item 4. Mr. Borbia Learned Counsel submits that a connected bail application is fixed on
13 July
13/7/2026 and submits that perhaps this matter may also be posted together with that other bail petition. Prayer is allowed. List on 13/7.
Along with my lord, bail application number 16/17 of 2026.
16/16/17.
Keep problem.
Number 5.
We have pleaded lordship. My lord, in this case, my lord, the petitioner number 1, my lord, is a my lord, authorized commons CSP center, my lord. Page 25 is the my lord certificate, my lord, and petitioner number 2 is his employee, my lord. This common service center is my lord established under the my lord Indian government, my lord, Digital India, my lord. Seva, my
What
lord.
happened?
My lord, what happened, my lord? Kindly turn to page 30. It's
Above.
the affair, my lord. And long affair, my lord, filed by the police personnel, my lord. Not a single, my lord, allegation is there, my lord, that we have committed some offense, my lord. Only on suspicion, my lord. Kindly see, my lord.
This is related to cyber fraud lottery, fake mule account, online fraud lottery.
Mule accounts.
Yes.
But nothing, my lord, is there that we have committed, my lord, only on suspicion, my lord.
It will be revealed from the case diary.
And my lord, I am being, my lord, I am the common service center. I am authorized by the bank, my lord, Government of India, my lord, Digital Seva, Digital India Seva, my lord, that I am authorized to do some, my lord, banking service, my lord, in the rural and remote area, my lord.
Third, London Council. Call for the case diary of Boko PS case number 175 of 2026.
My lord, kindly
The
during.
petitioner was
application, my lord.
arrested on 206/2026. Learned Counsel submits that he has an authorized customer CSP and he has been falsely implicated with allegations of indulging in cyber fraud, etc. Call for the diary. List on.
My lord, kindly second, my lord. Kindly, my lord,
No,
second,
no,
my lord,
not
because my lord, I am so only on suspicion, my lord.
No, these are not.
Nothing is there, my lord.
Vacation codes are for urgency, real
My
urgency.
lord, because
There is
this
a-
is
These
also.
are regular matters.
And lordship, there is a protocol for mentioning those urgent matters before the registry, lordship. There is a format.
My lord, kindly see the
All
affair, my lord.
matters
Nothing,
cannot
my lord, we have committed nothing, my lord. Only on suspicion, my lord. I have annexed the, my lord,
It's on
season list also, my
seven.
lord.
On lordship.
7 July.
Number 6.
Here, another similar matter is fixed on 16/7/26. Where the case diary has
already filed. Lordship was pleased to order for the case diary in the co-accused case.
That is
I believe the case diary would be necessary.
DA number 1730 of the
Answer.
Fishery department, relating to the
Oh,
fishery department.
she was arrested.
She was arrested. The last 32 days.
Acha. Ye Chaudhary Learned Counsel for the petitioner. The call for the case diary of ACB Police PS case number 30 of 2023. The petitioner was arrested on 26/5/2026. List on when have we
16/7.
16/7/2026 along with
Along with
DA number 1730 of the 26.
1730
Yes.
1730.
of 2026. Okay, take it up together.
DP applied.
Number 7.
Lordship, regular bail application, Lordship. Lordship, FIR is page 8, Lordship. May kindly translate it, Lordship. Married, Lordship. With due respect, I beg to state that I am a married woman and have 2 children. The accused person is my neighbor. The accused person used to visit our house. About 6 months back, the above named accused has given me hints to involve physical relation with him. After the rejection of the proposal of the said accused person, had tortured me in various ways and also threatened to kill me along with my husband and children. Lordship, as per registered the case, the 64 will not come, Lordship. And 72 Lordship will not come. Lordship, then Lordship may kindly turn page 14, Lordship, pro FIR, Lordship.
Page 14.
Page 14. Pro FIR. With due
Close
respect,
FIR.
I beg to state that the above named accused person is the a friend of my husband. Near about 1.5 years back, the above named accused person, by giving various inducement, learned me into a physical relation with him. The said incident has been video recorded by the accused person and has been blackmailing me for the past 1 year and 5 months. Thereafter, being fed up the said acts, I have disclosed the matter. Today, having been left with no other alternative, I am informing the said incident before the House Court. Lordship, now the actual fact is that, Lordship,
This was,
Lordship, the cross FIR was filed later on, Lordship, on 8/6, if I'm not wrong. And the impugn FIR is of 3/6. So this is an afterthought. Lordship.
we'll carry both, we can call both the FIRs actually.
Lordship.
Because the allegations are also similar, one upon one another.
Call
We
for-
can call both the case diaries. What do you say?
Another case is fixed today before the Honorable Justice, in court number 25, Lordship, item number 4, Lordship.
Case diary has come.
No, Lordship, shown stage, item number 4 today itself, Lordship. Then fixed both the cases together, Lordship.
I can fix.
We don't know, Lordship, what date is given in that.
Oh, yes, we don't know. But if CD was there too, it was no problem. Straight away sent it, but we do not know what. So what do you suggest? Heard Mr. Learned Counsel for the petitioner, who has drawn my attention, who has taken the court through the FIR dated 3/6/2026, in connection with which bail petition has been filed. This I have also been taken to another FIR dated 4/6/2026, lodged by Farida Khatun is, how is it related to Ajmal
Yes,
Haq?
Lordship. The present accused person, his cousin, brother's wife, Lordship. Same belong from same
Farida Khatun,
land dispute, Lordship.
family member of the accused, had filed a FIR against the husband of the informant of the case in which bail is being sought. Shall we get both the case diaries? Call for the case diaries of Boko PS case 145 of 26 and
Boko PS 153, coming.
Boko PS case number 156 of 2026.
63, Lordship.
Sorry, 153, make it bold. 145/26, 150 of 26. Date,
Date, Lordship, it will be on 15th July.
is it okay?
For date may be given. On 9, Lordship.
Lordship, this way, Lordship. Let it be on the, after reopening, Lordship, on 14th.
14th.
Obliged.
Can today maybe call for Lordship, charge ticket matter.
Along with medical reports or any such report that would be required.
POCSO matter.
No, Lordship, 376 is there.
Already charge ticket.
No private respondent, right? Mr. Mishra, Learned Counsel, A. Mishra, Learned Counsel for the petitioner. Learned additional people. Call for the scan TCR of what the case number? Of Sessions case number 62 of 2026 from the court of, where is it pending? Dotma,
Yes,
within bracket, arising out of Dotma PS case number 5 of
Sessions Judge
2026.
Kokraja.
From the Court of the Learned Session Judge Kokraja, the petitioner is in custody since 21/5/2026. The case is stated to be charge sheeted and presently at the stage of trial.
Charge has been framed.
At the stage of trial. List on
Also, let it be on 20.
207.
Can 9 also look at classification method, so scan copies will be.
Please, your lordship. Herein it is, I have already annexed the charge sheet, lordship. It is intermediate quantity. I am accused of possessing 31.69 grams of heroin, lordship. Whereas the small quantity is 5 grams and the commercial quantity is 250 grams, lord. 21B is the offense of which I have been alleged, lordship. Charge sheet is at page number 23, lordship. 35 copies I have submitted before the honorable court.
That's a record with all follow. You'll have to go to it. It's an NDP.
I am willing to cooperate, lordship.
What is the stage of the case?
It is fixed for framing of charge. Copies were furnished to me day before yesterday.
Framing of charge. And he's in custody since?
Since 16/4, lord, it's 70 days.
Let that share be called for, with a status report.
We can wait for the Caesar witnesses to be examined actually sometimes.
In the meantime, also you can call for the scan copy with a status report.
Sometimes it is, depends, no? Not always.
Intermediate quantity, lord. And marginally
16/4.
above the small quantity.
6 point something, no? 6 point something, anyway.
31.69.
So, heard Mr. Day, learned counsel for the petitioner. The call for the scan TCR of special NDPS case number 32 of 2026 from learned additional session judge Borpeta. Borpeta PS case 116 of 26. The petitioner is in custody since 16/4/2026. The charge has been framed.
Oh, lord.
The case is charge sheeted and pending for consideration of charge. List on
20.
0.
Not of them.
Number 10.
Commercial quantity.
Commercial quantity.
That's it is of
minimum toll.
The investigation is going on.
Yes, investigation going.
Call for the case diary of Majuli PS case number 14 of 2016, 2026. Number so and so. Petitioner is in custody since 3/5/2026. List on
17/7.
17.
Anybody given?
Scan copies of it, trial for record.
Scan copy. No, this is CD. This is scan copy.
Yes, 1911.
Item 11.
That's it, yes.
Charge sheeted case. Pertaining to NDPS. Yeah, commercial quantity. Then it will be necessary then. Call for the scan copy of NDPS 360.
No CD logic.
Yeah, it will be there. Scan TCR of NDPS comprising, I always say that, comprising case diary, charge sheet, and other relevant documents from additional session judge number 2, Kamrup M. Give the PS case, Gorsuk PS case 233 of 2025. The petitioner is in custody since 4/8/25 only. 25, last year, long time. 4/8/2025. What is the stage of the case? Trial has not started. Anyway, list on. Give on 17, possible.
They are-
17.
They are paying for 23rd month.
Okay, 23.
Oblige.
23rd. 23rd.
Symmetry motion be a property seven.
Is under kidnapping lawsuit, 140 subsection.
Just a minute. Good.
My lord, FIR at page, my lord.
Just a minute. No, just give me one. Just half a minute. 9. Yes, please.
May please, your lordship. But this is 483 application, my lord. My lord, petitioner arrested on 2/6, 2 days, 24 days behind the bar, my lord. And FIR at face, my lord, 9, my lord. A short FIR, my lord.
Attempted sections are also kidnapping, which carries a.
Demanding money.
Yes, that
Yes, my
will
lord,
be
kidnapping, abduction of person for ransom.
punishment for 10 years or life. So
My lord, the person, victim has already been recovered, my lord. Same day, my lord. Same day, that is at page, my lord, 3, my lord. Para 5, my lord, in my petition, my lord.
Just a minute.
Page 3, my lord, para 5, my lord.
Seven lakhs. 3 lakhs was paid for the release anyway. Page? Which page you want?
Page 3, my lord, para 5, my lord. Of my
Yes,
petition, my lord.
para 5.
Yes, my lord.
Monetary dispute.
Yes, my lord. After 2 months, the petitioner was arrested, my lord.
So, but still, I mean, suppose it is,
But
that
the
is
same
declared. You
the
should
date
not
of
take,
incident, my lord,
should not take law, you
victim
know.
was, my lord,
That's why he
recovered.
got into trouble, even if it is true, you know, isn't it? So, but, think we
Already
can,
24 days, my lord.
I'll fix it on 9, 7 or 9.
My lord, already the victim statement has already been recorded, my lord.
But because there's allegations of giving, you know, giving, using dowry on his neck, threatening with dowry, and money was, but then monetary dispute should not
Yes,
mean that
my-
should create offense, but
No.
anyway,
Offense is also 142.
yeah, offense will be offense even if it
It
is,
will be also 10 years. or-
even if it's the background of dispute, monetary dispute,
Yeah.
right?
What
So
monthly
anyway,
dispute?
so third, and so call for the case diary of Howley PS case number 46 of 2026. The petitioner was arrested on 2/6/2026. The petitioner has, the allegation is about kidnapping for ransom. It is submitted that the victim has been recovered and the learned counsel has drawn attention to para 5 of the bail petition post. Call for case diary. So and so. Fix one.
14, sir.
You can suggest
14,
14.
14, sir.
I'm obliged.
48.
Commercial quantity lordship, that's a pretty cover.
In this matter, section 36 and 48 has been violated. Just have it properly complied with.
No, so it's not given.
Not given lordship. I have the certified copy there.
48 is there.
Yes, lordship.
Total Bosama Tarif. Yes, 22. What is the infirmity in the notice? They've taken the signature. Total Bosama Tarif. 2, 47, 48 appears to be okay. Prime FSC. Anyway. Call for the, it is a scan copy will be
No,
necessary.
lordship, the
See,
investigation.
case the call for the case diary of Vipuria PS case number 81 of 26. GR 4, sometimes it helps within bracket, GR 445 of 26. The petitioner was arrested on 30/5/2026. The learned counsel submits that there is infraction of the notices under 36, 47, and 40, all
No, NS memo is like not properly complied with and section 48 is not.
36, 48. We'll see. Then you give a slightly,
17, sir.
okay, 70.
Obliged.
49.
49 lordship, scan copy may be called for.
Charge sheeted matter. Only my lord, lordship permits 2 grounds he is before the lordship. One, my lord, annexer 5, page 31. In that notice, lordship will find even there is no such column of taking my lord signatures. And secondly, my lord, he was arrested based on a confessional statement on 19/12/2025, my lord. So these 2 grounds he is basically before the lordship.
No signature taken.
Yes, my lord. In fact, no column is there, my lord. Secondly,
No. Then otherwise commercial quantity.
yes, correct. No, nothing recovered from him, my lord. He is taken to custody based on a confessional statement made by one.
What is the stage of the case?
My lord, presently it is fixed for supply of charge sheet on 6/7/2020.
Copies.
Yes, ma'am.
Also. Mr. Learned Counsel for the petitioner. Additional people. Call for the scan TCR of NDPS 4 of 26. Within bracket, Karimganj 353 of 25. Comprising case diary, charge sheet, other relevant documents. Petitioner is in custody since 19/12/25. The Learned Counsel submits that there is infirmity in the arrest memo under section 36 BNSS. List on, kindly work out the date. Can you work out the date, please?
6 plus 7,
17
of like 7.
May it please your lord. This is a regular bail application, my lord. The page 8 is the FIR, my lord. May I read, my lord?
Page 8.
Yes, my lord.
He was arrested on 11/5.
Yes, my lord. 11/5.
2%.
As on today, he is in custody since 47 days, my lord.
2%.
60 days offense, my lord.
Kindly read.
Yes. With due respect, I, Srimati Monica Kolita, wife of Sri Nomal Kolita, would like to inform you that last night when my son, namely Samarjit Kolita, aged 17 years, while he was returning home at 2 a.m. after attending the Bihu function held at LP School Japuriguk, certain persons, namely Rohit Vaishya, that is petition number 2, my lord, Boone and Kolita, started to argue with my son, and then person, namely Ban, attacked my son with a knife on the backside of my son, and 3 of them beat my son badly. As a result, my son is admitted in ICU of the GMC hospital, my lord. This is the allegation, my lord. And the facts of the case is that, my lord, on the date of occurrence, my lord, the petitioner number 2, along with others, were returning back to home, along with the son of the informant, my lord, and their minor altercation was took place between them. Or shuffle was took place, my lord. Accordingly, and petition number 1 is not named in the FIR, my lord. And the sections are involved in the 60 days offense, my lord, and all
90 days offense. So there is 126(2). That is 90 days offense.
Raju Lali.
90 days offense. Lordship will kindly come to page 16.
Raju Lali is not named in the
No,
FIR.
not named.
Kindly come to page 16, Lordship. And so in page 16.
Forwarding report.
Yes, page 16, Lordship, may kindly see. Number 1, Lordship. During the course of investigation, 2 eyewitnesses who were present at the time of incident, along with the victim boy, were examined.
Okay.
They specifically named both the arrested accused person and stated the accused physically assaulted the victim and thereafter attacked him with a knife from behind, causing serious injuries. The witnesses further stated that they were also assaulted by the accused person without any provocation.
You need the case diary along with
Yes.
medical report.
Yes.
My lord,
It is a 90 days offense.
my lord, 126(2) is the bailable offense.
This would be, depends on the injury. It could be 326. It could be 326 and even 307 also, depends.
May I extend to 10 years?
Heard, Learned Counsel has taken the court through the FIR. The allegation is about assault and causing of injuries, serious injuries on the victim who stated to be in ICU of GMCH. Call for the case diary of Dispur PS case number 279 of 26. Petitioners are in custody since 11/5/2026. Call for the case diary along with medical report.
Can it be on vacation court, my lord, if possible?
Vacation court is not for this purpose, Lordship. There is a protocol for listing matter before vacation.
Court 14.
Be clear.
51.
Lordship, trial court record may be called for. Classification method.
The record will not be required, my lord, because my lord, the FIR and forwarding report will show, my lord, that he was produced before the learned magistrate, my lord, after 24 hours. He was arrested on lordship kindly see page 15 is the FIR. Page 15, my lord.
Hmm.
On 7/3/2026 at about 10 PM, my lord. Occurrence, my lord. And page 16, my lord, he was taken to police
This
station
is-
on the same day.
This date, this time, His Lordship, a reliable source information was received on this time, Lordship.
Page 16, my
Our
lord.
day stating
Page
that it is
16.
the time of offence.
Page 16, my lord. Page 16, after completion of all necessary formalities, the police party returned to police so-and-so police station along with the seized article and apprehended accused.
Date and time of arrest 9/3.
Now he was kept in police station for 8 of March. 9/3 he was shown arrest and produced, my lord. Page 17. The issue has been settled by the Honorable Supreme Court and your lordship has also passed order, my lord. Your lordship order and relying, my lord.
Also, we need the records, Lordship. We'll have to verify the records.
Yes, perhaps we can fix it on 7 or something.
Second, my lord, second.
7 or second, whatever.
Second,
Second would
ma'am.
be too less, I think. Will it come? Scan record may not come. Scan, CD may come, but scan record may not come. Good stuff.
Even in
Learned counsel, heard. Call for the scan TCR of NDPS, special NDPS case number 22 of 26. Allopathy Char, PS case number 16 of 26. Comprising case diary, charge sheet and other relevant documents. Otherwise, what is the stage of the case?
evidence, my lord.
Huh?
Fixed for evidence.
The case is at the stage of, stated to be at the stage of evidence, full stop. The Mr. Ali, learned counsel submits that the petitioner was formally apprehended prior to his actual arrest but produced before the magistrate beyond the period of 24 hours. We'll keep this. We'll fix it on
Second, my lord. Second of.
Won't come, your scan copy will not receive.
7. No, scan copy may not come actually. 7, let us say. Give them a week. From which court? We'll mention.
From Borpeta, my lord.
Borpeta.
Lord.
From learned special session judge Borpeta. Huh? Session judge Borpeta.
Special judge Borpeta.
Special judge Borpeta. 7. Good.
Deeply ordered.
52.
Wait, please, my lord. This is listed under section 21B, my lord. But it is the small quantity, my lord. The margin is that, my lord, 5 milligram to small quantity and 5 grams to small quantity and 250 gram is commercial quantity. And
Heroin. No, 5 grams is?
small quantity,
No,
my
it is intermediate quantity.
intermediate
five-
quantity and only 91 gram heroin along with container, my lord. So, that is
21B.
on the actual contraband is below 91 gram, my lord.
Lordship will kindly come to page 15 for a moment.
15.
15, for a moment, Lordship.
FIR is
Point
one
number
not
4.
I'll come to.
Point number 4, Lordship, may kindly see.
four syringes suspected to have been used for false with NDPS substance.
Habitual offender. And today is 34 days, Lordship, to my.
Today is 36 days, my lord. Arrested on 22/5/2026, my lord.
Yeah, it will be necessary, of course. Same. Where is the quantity mentioned?
Yes, it is
91
mentioned in
grams.
Lordship,
Let's do.
As per FIR, my lord, 91 gram along with container, my lord. Plastic bag,
91 grams.
21 grams. So not difference of small quantity below
They
100
usually
gram.
mention 5 grams is 5 grams and above is intermediate quantity. Below 5 grams is small quantity. Anyway, Kolita learned counsel for the petition. Instead of call for the this investigation, call for the case diary of Azara PS case number 61 of 26 under.
Unless sorted may be given, madam.
The learned additional PP has drawn attention to the forwarding report, which also mentions 3 other criminal cases under the NDPS Act. 3 other criminal cases pending against the petitioner, including two of these under the NDPS Act. Full stop. The petitioner was arrested on 22/5/2026. List on
15 UMDC.
15.
Let on the 7th July, madam.
Let it be on 15 too. These are regular matters.
July. And
15. এটা আছে তো motion. Criminal petition. Every piece দিব. Every piece দিব. Yes, please.
My lord. My lord, FIR is page 11. Here is my lord. Offense under section 182. Lord, voluntarily causing grievous hurt.
Mhm.
May I read, my lord? Relevant portion of the FIR. Page 11 is the relevant portion, my lord. I, Srimati Resma Ronghampi, 31 years, wife of Sri Anupam Kempari, resident of village Hardik, Rong, post office Tampering, PS, Boithalangsu, district West Karbi Anglong, Assam, most especially submit the following for your kind consideration. That yesterday dated 13/5/26 at around 2 p.m. at Haldik Rong, Tampering, that one account of our cattle accidentally entering the crop field of the accused persons Sri Sajal Roy and Sri Ranajit Biswas. The accused detained our cattle. Subsequently, my elder brother-in-law and younger brother-in-law, Sri Montu Kamparing and Sri Pradip Kampari, went to the said place regarding the matter. Therefore, Sri Sajal Roy and Sri Ranjit Biswas called my brother-in-law on the pretext of peaceful resolving the issue at Haldirong, Tampering. Trusting their words and having no intention of violence, they went to the spot. However, after reaching there, Sri Sajal Roy and Ranjit Biswas and along with other villagers. My lord, this line is important for me, my lord. Along with other villagers of their village who were already prepared and with bamboo sticks and other deadly weapons, suddenly launched a brutal and merciless assault upon them. After that, Sri Sajal Roy and Sri Ranjit Biswas intentionally attacked my brother-in-law Sri Mintu Kampari and Pradip Kampari on their head and other vital parts of their bodies. They continuously assaulted them in violent and causing grievous injuries all over their bodies, specifically severe head injuries. After that, they are sent to the hospital for treatment, my lord, and now they are under treatment. My lord, I want to submit in support of my petitioner, my lord. Actually, admittedly, there was a
Altercation.
incident, yes, took place
Incident.
between the parties, and injury was caused by the along with villagers also here. In this FIR, my lord, made allegation against the villagers also. My lord, and present petitioners Sajal Roy. Sajal Roy role is my lord, nothing here, my lord. I am praying for interim protection in respect of the petition.
Some allegations against him, of assaulting on head.
The medical report may be produced.
Medical report.
It is punishment for life or 10 years. So let the city.
Mr. Azad, Learned Counsel, and additional people. The Learned Counsel has taken the court through the FIR. What is the date of the FIR? 14/5/2026. Full stop. The allegations pertain to assault and causing of injuries. Full stop. Call for the case diary of Boithalangsu PS case number 14 of 2026 along with medical/injury reports, if any. When do you propose a date?
17?
List on 17th.
May I please address? FIR case, my lord, 7, my lord.
7?
7, my lord. 7, my lord. Allegation is against the petitioner, my lord, regarding the abatement of commission of suicide, my lord. The wife of the informant, my lord, committed suicide, my lord. In this case, my lord, I was implicated, my lord. FIR case 7, kindly see, my lord.
Okay.
I'm seeking for an interim method.
Will not be justified because of there are some direct allegations against him. Third, call for the case diary of Haju PS case number 198 of 2026, including PM report if available, full stop. List the matter on, give it immediately after reopening, short date.
16?
15. 16. Unlisted. Oh, no, I don't elaborate after. I wrote the, oh, no problem.
Okay. May I please, my lord? Inform
Yes.
the wife of the petitioner number 1 and my lord, daughter-in-law of the petitioner number 2 and sister-in-law of the petitioner number 3, my lord. The FIR is at page 14, my lord. The allegation is that against the petitioner number 1 is that, my lord, she caused abortion to the, my lord, informant. And the allegation against the petitioner number 3 is that he is stunted relating to going to mother's house. And the allegation against 2, my lord, is that he caused physical and yeah, and they spitted on the body of.
Let me see the FIR.
My lord, kindly, my lord, some protection, my lord, because petitioner number, the FIR, my lord, page 14, my lord. Page 14.
There are 2 FIRs. No, sir. One FIR.
One FIR is lost by the mother-in-law, my lord, and the page 14, my lord, this is the informant's FIR, my lord. Page 14. May I read, my lord?
Yes.
Most especially, I beg to state that on 22/1/2026, I got married socially with Pankaj Chandra Rava. After 1 month of marriage, I got pregnant, but my husband Pankaj Rava told me that the responsibility of mental and social slander and maintenance cannot be taken. I was taken to Aruna Memorial Hospital without my total consent, and on 15/2/2026, I was administered medicine. And after taking this medicine, my child was ruined, and after 15 days, post-abortion. And from then, my husband, Sri Pankaj Rava, my mother-in-law, and Konika Rava and her younger son, Mintu Rava, started plans relating to going to my mother's house, cooking rice, curry, calling my younger brother and mother, drinking water, throwing flowers of temple under Tulsi, using fan on hot, and caused physical and mental cruelty for the reasons to be increased expenditure. And I and told that why of these talks, if you inform to your brother and mother through messages, my mother-in-law assaulted and spitted on the body. My mother-in-law did not allow my husband to remain with me and told to remain separately, though I had been suffering from fever since 3 days. And for this, on 12/6/2026, 2 a.m., I called my younger. There should be brother Malo missed for causing my treatment. Therefore, after my younger brother came at 2:45 a.m. Thereafter, my younger brother was confined inside the house and called person and assaulted and insulted both, and I dialed 100 as younger was framed, thief, and confined. And thereafter, police sent me along with my husband to GMCS. and he left BMC saying that I would not taken back to husband's house again. For this, I informed the Oman police station Panbajar, and they asked to go home after writing. And today on 14/6/2020, I came to home. My husband escaped, keeping the door fastened with a padlock to prevent me from entering into house. Therefore, it is paid before your good self to help me to enter into the house. Prior to that, my lord, on 12/6/2026, my lord, FIR was lodged before the Oloman police station, Panbajar.
By her.
Yes, by her.
Monica.
Then petitioners were directed to appear. Petitioners were appeared, their statements were recorded. I have stated in page 7, para 9, my lord. It was my GD&T number 10/12, dated 12/6.
No, the mother-in-law lodged an FIR.
That is, my lord, on annexure C, my lord. Subsequently.
Subsequently.
That is the mother of the petitioner number 1, my lord, and she is the petitioner number 2, my lord. Pungaraba. Stating that daughter-in-law creating problem and inflicting mental and harassment, my lord, all these things, my lord. And regarding the lodging of false FIR before the Panbajar police station also, that was also mentioned, my lord. So, my lord,
Just a minute, let me see this.
that is, my lord, Konikarava lost FIR is page 26, my lord. Annexure
I've seen, just give me. This is on the same date. Case was registered.
That was, I don't know, my lord, that was part of, annexure C, my lord.
Same day.
Same day. But it was received, my lord, seal is there, my lord, it was received, acknowledged the receipt, my lord. Regarding not causing miscarriage or abortion, my lord, there is a WhatsApp messages, my lord. I have annexed, my lord. And it reflects that, my lord, from the messages, my lord, this allegation is totally false, my lord. When the FIR was lodged before the, my lord, Oloman police station, the regarding, my lord, abortion, that was not mentioned, my lord.
I think the FIR lodged by the mother-in-law is just it's not registered also. So this is the main FIR, I think. So the allegation against the husband, maybe brother-in-law we can consider, maybe.
My lord,
Younger, Mintu Rabha.
my lord, mother-in-law, my lord.
Because
Kindly, only, my lord, only allegation is that, my lord, he's beaten on the body, my lord. This is also allegation, my lord. Kindly see, my lord,
498 also will come.
my
Because
lord,
these
kindly
are,
see, my lord. Kindly see the WhatsApp messages, my lord.
I've seen.
That is the, my lord, he does not want to carry pregnancy, even, my lord, she threatened, my lord, page 24, my lord, last line, my lord. If anything happened to me or I become pregnant, I shall give FIR on his pharmacy, my lord. That is the, and my lord, from the top, my lord, after 2 lines, my lord, if abortion is not done.
Ill treatment has emerged from
Because of
the
the
FIR.
baby remains.
Ill treatment and cruelty, these are have to be strict, hard learned concepts and so.
Team protection may be given, my lord.
Additional, the learned, the allegation, and the FIR has been, FIR dated 14/6/2026 has been lodged by the wife of petitioner number 1, who was married with him on 22/1/2026. It is alleged that subsequently she got married, she got pregnant, but the petitioner number 1 refused to take any responsibility, and after taking her to one hospital, without her consent, administered some medicines on 15/2, leading to miscarriage. Full stop. There are also allegations against the husband as well as mother-in-law regarding taunting and ill treatment. Taunting, ill treatment, and cruelty, mental cruelty, full stop. And cruelty, mental, physical also is there, full stop. The learned counsel prays for interim bill. However, Upon going through the FIR, I am of the considered view that such interim protection should can be considered only for petition number 3. The Mintu Rava stated to be the brother-in-law at this stage. Full stop. Call for the case diary of which PS case number? Dispur PS 388 of 2026. However, in the interim, in the event of arrest of petitioner number 3, 20,000 with one security of the like, cooperate with the investigation record is state. Full stop. List immediately. You can give it on 13th also. You can.
Petitioner number 2 will consider,
No.
she is a lady, my lord.
Sometimes the ladies are, we don't know, we don't go by gender, but there are materials against them. The allegations are there.
Early date, my lord.
Only 3.
Early date, my lord, sir.
13.
My lord,
13.
maybe 7, my
13.
lord.
Because vacation court, I don't know, that's a protocol will be different. 15. Exigency is there, then it can be fixed. If there is an exigency, like violation of some procedural thing or something.
Maybe, my lord, during the vacation, my lord.
13.
This FIR is lodged, my lord. It is the dispute between the family members, my lord. And the dispute arises out of the, my lord, the boundary of home state. This is the fact here. May I read the FIR, my lord? Very clear.
Yes.
Respectfully submits that on 30/5/2026 at about 11 AM, the aforesaid accused persons in a pre-planned manner with the intention to kill came to my house and on appearing at home, at first Ahaduddin had started altercation with my husband and thereafter the accused number 2, 3, 4 attacked him with iron rod and later the accused number 2 had made a blow at the head of my husband with a spade which was in our home for which he sustained severe injuries. Before that, my lord, this is the line. Before that, my husband often assaulted my son for which he sustained severe injury. The case relating to said incident is pending before the court of law. So the my lord, victim earlier attacked the son of the informant.
What is it?
So whole incident, my lord, it is the dispute between the family members.
Jahan.
And my lord, kindly see para 4, 5 and 6.
Just a minute. Huh?
Page 14, can you see?
2 and 3 are before, na? Accused number 2 and 3 are before this.
Before, my lord.
Let me read the FIR again. 111. This person. First time it started. Profession. Sentence I have not understood actually.
This is the fact, my lord. May I submit, my lord?
Just a minute. He wants to show me something. Yeah, please.
Lordship, seen the English version of the translated copy of the FIR.
Yeah.
Here, Lordship is pointing out before that my husband often assaulted my son,
Ah,
for which he sustained severe injury.
please read that.
Now, Lordship will kindly come to the Assamese version, page 14.
Hmm.
Here, Lordship, down below, Lordship will find এই আগতেও আমার স্বামী আৰু আমার ছেলেকে মারধর করি গুরুত্বভাবে জখম প্রাপ্ত করেছিল। It does not say,
Oh,
Lordship, that
earlier incident.
আরো নহয় প্রায় my lord, it is a Bengali, my lord. আমার স্বামী প্রায় আমার ছেলেকে মারধর করে। এটা বেঙ্গলি আরো নহয়, my lord. This is প্রায়, my lord. প্রায় often.
yes, it
So anyway, but that is
means
a
often,
different thing.
My lord, what happened, my lord, exactly? This is the petitioner before your lordship is the nephew of the victim, my lord. This is in fact, my lord, it is a dispute between the boundary. What happened, my lord? Kindly see, my lord, kindly see for a moment, para 4, 5 and 6. What exactly happened, I am narrated, my lord. I have discussed. This, the wife said that the husband attacked earlier the son of the victim, my lord. That is his own son, my lord. So what it means, my lord, it is a family dispute, in fact. This is, my lord, reflected in the FIR itself. My lord, kindly see page 3, para 4.
even then,
Para
Lordship,
3,
these
4 and 5.
sections- The sections that are attributed are, Lordship,
These
attempt to
sections,
murder,
sections are, my lord, it's not,
Lordship, attempt to murder and grievous hurt, which carries punishment for life. Lordship, can you see the FI itself states that they are currently under treatment. at
Difficult to make out
Doctor
actually
Hospital.
now, you know.
Or-
Yeah, the alternative theory is difficult to make out
Yes,
now.
it is not clear. Lord.
Incident by 35/2026. FIR lodged on 2/6/2025 after 3 days of alleged effort,
Maybe they were
occurrence, my lord.
hospitalized.
And there is no explanation here, madam. Or why there is delay. So it is a, my lord, if there was an amicable settlement, everything has done, my lord. But still the FIR still exists. So my lord, kindly see para 4 for a moment, para 4, 5 and 6. What exactly happens, I have my lord discussed.
So the CD come Lordship, because he is presently undergoing treatment in Downtown Hospital. We'll produce the medical.
Some assault is there. that
Yes,
means.
yes,
I'm assured, no,
definitely there.
we have received also asset, madam, because it is a boundary dispute.
Mm.
So my humble submission, my lord, the two young boys, my lord, may be protected, my lord. City may be calm, my lord, it will reflect everything.
Counsel for the
Matter is
petitions.
there.
Call for the case diary of Pathar Kandi, PS case number 69 of 26, along with medical report. Full stop. The allegation in the FIR dated 3/6/2026 pertaining to assault upon the husband of the informant, and who stated to be presently under treatment in Downtown Hospital of Gauhati. Full stop. The learned counsel submits that the allegations are false and there is a dispute. There was that the petitioners and the informant side are family members, and there was a boundary dispute which was in the process of being settled. Full stop. We'll call, you can give him an early date. but-
I think it's from Sri Bhubi Lordship. So let it be on 15th, Lordship. 14th,
In 13,
13th,
13.
13th.
My lord, my humble submission, my lord, 3 days of alleged incident, my lord.
Oh, that's
So
good.
Primarily, it is
At
a, my
least
lord,
is-
not case at all, my lord.
No,
But interim,
on-
my lord, two young
On what
boys-
ground? No, tell me the reason why interim should be granted.
Yes.
Why we, their custodial interrogation may be necessary
Yes,
also,
that
at
was
least,
the
at least is.
Attempt to murder.
You know, let us see.
My-
Injury on the head
60.
has to be a reason.
Transited metal Lordship.
The petitioner before your lordship is a poor vegetable seller.
Hmm.
Uh,
What
the
happened?
case- Your lordship will find the FIR at page 13.
Yes.
This is a case which was registered 26 years ago.
Driving the truck, huh?
Yes, alleging that some unknown persons had taken 2,000 rupees from the complainant.
Just, let us read it. I beg
May I
to
read
state-
it?
oh, yeah.
নিহিত নিবেদন এই যে যোৱাকালি ইংৰাজী 13/4/1999 তাৰিখে মই AS 023796 ট্ৰাকখন চলাই উমৰাংচুৰ পৰা বৈঠালাংচু অভিমুখে আহি থকা অৱস্থাত খেৰণী চাৰিআলি আৰু দুৱেংমুখৰ মাজত বৰকাপ্তানি পথত খাল বাগানৰ ওচৰত ৰাতি প্ৰায় 8:30 মান বজাত 6-7 জন মান অতি অচিনাক্ত দুৰ্বৃত্তই হাতত বন্দুক আৰু কুকুৰি লৈ মোৰ ট্ৰাকখন ৰখাই মোৰ পৰা 2000 টকা লুট কৰি পলাই যায়। লগতে মোৰ ট্ৰাকৰ চাবি কাঢ়ি লৈ যায়। বহুত চেষ্টা কৰি এই ট্ৰাকখন ষ্টাৰ্ট কৰি ৰাতি প্ৰায় 11:45 মান বজাত খেৰণী থানাত ঘটনাৰ বিষয়ে মৌখিকে জনোৱাত পুলিচে জনোৱাত থানাৰ পুলিচে লগে লগে ঘটনাস্থলীলৈ যায়। So in the FIR his name is not there. Now your lordship may kindly see the charge sheet
The case was registered in 99
in 99.
and charge sheet was filed in 2005.
2005.
And what it is still pending.
It is still pending because lordship why? In the district of West Karbiang there was no judicial court. It was an executive court decided by an ADC, and therefore lordship this all had happened. In 2019, the judicial court was opened up, inaugurated. Your lordship will find the charge sheet. In the charge sheet, he was shown as absconder. Your lordship will find his name at page number 21. Serial number 2 is his name. The charge sheet was filed against 8 persons. 6 persons were shown as absconder. In fact, out of the 8 persons, 2 were already passed away.
Naturally, he must be, how old he might have been at
Now
the time?
he is just 47 years of
At
old.
the time he was young.
At that time, he was just
Oh, if it's 47, he would be juvenile at
yes,
the time, isn't it? Okay, he may be juvenile. at
no,
the time,
19
47.
years probably.
26, 27 years. Or something like that.
Yes. So the charge sheet was filed based on the confessional statement of one Jamaluddin Talukdar, who was arrested on a different case. That your lordship will find at page number 23.
Anyway, it's very peculiar, actually, so many years. I think we can give him some,
Lordship, he is a poor
interim.
vegetable seller, lordship.
can give him interim after so long. I mean, it's, well, shall we call for the records?
The records, lordship, the matter is fixed on 14th of July 2026. So he will appear before the learned trial court.
Dispose it of for,
Yes, he will appear before the trial court, lordship. The difficulty for him is that once he appears, he will be taken into custody. And in fact, I have got.
should we dispose it off or call for the record?
In fact, I have got the information
Dispose it
that
off
the
also.
lordship, the complainant also passed away. So
A long time.
Yeah.
Anyway, so I think we can dispose it of this. Heard Mr. Learned Counsel, Mr. Bora, and a learned additional people first. The petitioner, Amrit Dibra, is seeking anticipatory bail in connection with PRC number 445 of 2020, within bracket, arising out of Kheroni PS case number 53 of 2099 under section 395 IPC in the district of Karbi Anglong. Full stop.
West Bengal.
West Karbi Anglong.
West Bengal.
West Karbi Anglong. The case is full stop. FIR dated 14/4/1999 was lodged by one Azmal Ali with the allegation that on 13/4/99, while he was driving truck number AS023796 from Umrangsu towards Voitalangsu, at around 8:30 PM, 6-7 miscreants, unknown miscreants, armed with guns and kukris, stopped him and looted rupees 2,000 from him. Subsequently, he somehow reached Kheroni PS around 11:45 PM and verbally informed about the incident. Interestingly, upon investigation, the case was charged sheeted in 2005 by CS number 19 of 2005. Full stop. Charge sheet was filed against how many persons?
8 persons, lordship.
Against 8 persons, and including 2 absconders.
6 persons were absconders, 2 were in custody.
Against 8 persons, and including the present petitioner, who was indicated as a present petitioner Amrit Dibra, who was indicated as an absconder in the charge sheet. The Learned Counsel has annexed the photocopies of the certified copies of the charge sheet and order of the learned JMFs. Also heard learned additional people first. It's dacoity otherwise, no? It is submitted that 2 of the charge sheeted accused persons have probably passed away, have expired in the meantime. That's so. Considering the peculiar facts of the case and the long elapse of time, and also the stage of the case, it is, I'm of the considered view that the matter can be disposed of at this stage itself. Accordingly, it is directed that in the event of arrest of the petitioner in connection with this case, or in execution of the NBWA stated to have been issued against him, he may be allowed to go on bail of rupees 30,000 with 1 surety of the like amount to the satisfaction of the arresting authority, and subject to the condition that he shall not abscond and shall appear before the learned court below on next and subsequent dates. Next, he shall be available for trial if one commences. He shall not hamper or tamper with evidence. Upon appearing before the learned court below, that is learned CJM West Karbi Anglong, Hamred, the petitioner may furnish fresh bail bonds, whereupon necessary orders shall be passed.
But BWA has been issued, not NBWA.
BWA.
NBWA was issued in the year 2005, and then subsequently BWA.
Then you can delete that part. The bail petition, the petition stands allowed and disposed.
Much obliged.
70
Yes, 15 is the FIR, Your Lordship.
Page 15.
1-5. Here in the accused number 1 to 4, they are the brothers, Your Lordship. Accused number 1 to 4, they are the brothers, Your Lordship, and the accused number 2 to 4, they are before Your Lordship.
1 to 4 brothers, 2 to
Yes.
4 are.
Yes.
What is the allegation?
Allegation is that, Your Lordship, here in the allegation of extortion, rape, kidnapping, all everything is in here. But allegation of rape is against the 1-4 brothers, Your Lordship. Just 15, Your Lordship.
You want to read it?
Yes, I am reading here. Bosoria, I'm reading the translated copy, Your Lordship.
Okay.
This 11, Your Lordship. The government has evicted the house of the informant a few days ago. After eviction, the informant along with her family used to stay as tenant at the house of Rezabul Haq of village Ashudubi. A few days ago, the husband of the informant, namely Wazid Ali, was arrested by the police for committing crime and kept in jail. Taking advantage of staying in jail of the husband of the informant, on 3/9/2026 at night, the accused person had made a joint conspiracy and forcefully kidnapped the informant while she came out from the house. And thereafter, she was confined in the house of the accused number 5 and forcefully committed rape against her will. Moreover, on 4/3/2026, the informant was threatened to kill by showing regard, and the ornaments remained with her, such as gold chain, owing swansu, 1 pair earrings, swansu, 1 pair gold bangle, swansu, gold ring,
So many allegations.
have been forcefully snatched away and sold, and were also taken signature in some blank stamp papers. There is possibility to prepare valuable documents with the help of the signed blank papers, which may be used against the informant. The accused person confined the informant with effect from 3/3/2026 to 27/4/2026. And during this period, the informant was forcefully committed gang rape, and on 28/4/2026, the informant was driven out from the house of the accused number 5. And this instant affair, it was filed on 5/5/2026, Your Lordship. But in fact, Your Lordship, the informant and the petitioner, they are the co-villagers, Your Lordship. And the informant, she is a married lady and he has 2 children, and she had developed extramarital affairs with the accused number 1, who is the brother of the present petitioner, Your Lordship. And while the husband of the informant was in jail, at the time the informant came to the house of the present petitioner with a view to enter into marriage with the accused number 1, Your Lordship. And the present petitioner opposed that act, Your Lordship. And consequently, they used to stay at the house of the accused number 5 as tenant, Your Lordship.
We do not know at this stage where the Hazrat Ali is not named in the FIR.
The
Fakir
Hazrat
Ali.
Ali is named in the affair,
Fakir
but
Ali.
his Fakir, Your
Yes,
Lordship.
Fakir Ali. All are named in the FIR.
But in the meantime, Your Lordship, what happened, Your Lordship?
He was confined for 2 months according
Yes,
to the
2
allegation
months, Your Lordship.
and gang rape. So I think
And in the meantime, Your Lordship, another affair was filed against the present petitioner and the accused number 1, and subsequently there compromise there was, and this 17, Your Lordship, kindly have it. And on 7/3/2023, he made an application before the police that we have compromised the dispute, Your Lordship. It is not this 17, Your Lordship.
do not know.
So therefore, Your Lordship, the confinement part, Your Lordship, she has stated that on 3/3/2026 to 24/4/2026, she was confined. But in the meantime, Your Lordship, one more affair was filed by her, and subsequently, and that one was amicably settled under the intervention of the elderly person of the locality. And thereafter, a joint application was made before the police for withdrawal of that affair, Your Lordship. But I am only praying, Your Lordship, for protection, because the rape, Your Lordship, allegation of rape against the one brother, Your Lordship.
No, because
Accused number 1 to 4, they are the brothers, but
lot of allegations, confined for 2 months.
that is also unbelievable.
Well, because of that, your lordship, he was confined on same village, your lordship.
Forcefully committed presence of will.
And during the period of confinement, page 17, your lordship, kindly see the date.
Fully, there's no-
1/7/3/2026, it was made. And she has stated that was 3/3/2026 to 24/4/2026, he was confined. But in the meantime, your lordship, this application was made before the.
M. Khan, learned counsel for the petitioner and learned additional people. Full stop. Here is the FIR dated. FIR is dated 11/5.
5/5.
5/5/2020.
That is
5/5/2026. Full stop. 5 accused persons are named, including the present petitioners. Full stop. The allegation is about confinement and commission of sexual offense. Full stop. And also taking away of valuables from the informed victim woman. The learned counsel prays for interim protection. Call for the case diary at this case of Krishna PS case number 33 of 26. Okay. Fix a date, please. Fix a date. No, you can, you give a date.
17.
17.
All right.
Matter of. A lady with 1 year child, my lord, drug offset, my lord. And you also kindly see the, my lord, FIR, page 17. Wife, my lord, her husband actually got admitted in a hospital for a respiratory problem.
Mhm.
Ultimately, after 1 month, my lord, he died.
Mhm.
Page 70, kindly see, my lord. And 15.
Okay.
Then kindly see, my lord, next page, page 18. FIR is dated 205, your lordship, page 17, 205. And it was registered, my lord, your page 18, on 17/6,
So long.
after about 1 month.
Hmm.
The learned CGM seen also on the same day at DPM.
Hmm.
Your lordship got it, man.
Allegation of trying to attempting to kill.
Right. He was in admission, admitted in the hospital. This is the allegation. But in fact, I take your lordship to just death certificate in the page 30. That is, they have not mentioned in the FIR. madam. All the FIR was after his death, man. It is not mentioned in the FIR. Page 30, your lordship can see this name of the my husband, my lord, Rakesh Pomma.
At page?
Page 30, last page.
Please.
His certificate from health city Gauhati.
P0.
Yes, man.
Lower
Name of
respiratory
the
infection
patient?
with severe distress syndrome.
Rakesh Pomma, date, your lordship, date of admission, your lord, can see right side. 28/5/26. But after the dated 20, my lord, your lord, nothing mentioned in the FIR. Date of death is, my lord, 17/6/26 at 5:41 AM. AM. And FIR kindly see, my lord, page 19, kindly have page 19. Page 19.
Page 19.
Yes, 1 line. A format, my lord.
Mhm.
Your lord kindly see 3. So, Wakaran 17/5/26.
Mhm.
And your lordship will find time is 17/5/21, 9 PM, my lord.
Mhm.
Then your lordship
Information
find information received, your lordship kindly see. 17/6, 8:12:10 hours. And he died but in the morning. Nothing mentioned in the FIR. So, and certificate I got, you already might have respiratory problem. Yes.
There's another FIR or
Yeah, this present, that is husband, my husband filed case against the present informant
deceased.
in 17, my
Got married
1917,
with Saini Brahma.
1917.
Just a minute. I'll
Yes.
go through it. This is a different FIR, I think.
Well,
This is a different FIR. I think.
no, this my
How is it
husband
related?
filed against mother, my against informer.
Mother, but this is
Then you have the kind of 107 also.
mother.
Here. The problem is
Accused
minor
my
something
daughter-in-law.
else, madam. This lady belongs to Bengali community. Husband
Okay.
belongs to my Bodo community, Christian. That's why my family could not accept them, madam. There, because of torture, they came, my son, in another suburban accommodation. There also they came and started this disturbing. This person, my ultimately finding no way out, my lord. He ultimately he also started the physical, my mental stress, my lord. Then your lordship, and after 1 month, more than 1 month he was in hospital. I have taken him to hospital to Gauhati, my lord. Initially local hospital, then my lord, they have got to Gauhati city also.
What do you say?
And she is having my 1 year child also. I have given birth certificate also. My lord. Your lordship, kindly the birth certificate. 1/6.
First, prima facie, it is a serious allegation, but if there's another aspect,
I admit, my lord.
Yes.
I admit.
I mean,
Something is there, my lord.
you're trying to say that it was after, because they had disputes between, they had a relationship problem, and
Yeah.
after her son died, she was falsely implicated, something like that.
Yeah, this is my case. Something only because of that, my lord. Actually, this lady is nothing matters, nothing.
You can see the CD and maybe.
Health report come, PM report come, your hospital. This is the health city, your very important hospital, famous hospital.
Senior counsel learned, Chari Chaudhary, additional things. The petitioner is seeking anticipatory bail in connection with
Ukraja, yes.
Kokrajar PS case number 92 of 2026 under so and so section. Will it be proper to give interim? Anyway, maybe there. Anyway, let's see. In connection with so and so under so and so section, the case arose out of an FIR dated 17/5. 17/5.
FIR is 220. 205. FIR.
205/2026 lodged by the wife of, lost by the mother of the deceased, who was married to the present accused petitioner.
In 2012. When it
It is submitted that the marriage was solemnized in 2012 itself, and the
having
the
two
petitioner
children.
and the deceased, they have 2 children.
Yes.
They have, the petitioner and the deceased have 2 children, with the younger one
1
being
years, another is 1 year.
aged 1 year. Full stop. A copy of the birth certificate has been annexed. Full stop. The allegation in the FIR is that on 17/5/2026, in the night, the petitioner tried to kill the informant's son by administering poison, and as a result of which his health deteriorated, and that he's undergoing treatment in Bongaigaon in critical condition. Full stop. As per the certificate from Health City Hospital, Gauhati, the deceased was admitted on 28/5/2026, and he expired on 17/6/2026. Full stop. The cause of death has been mentioned as lower respiratory tract infection with acute respiratory distress syndrome. Full stop. There's no mention of any about finding of any toxic or poisonous aspect in the said certificate. Full stop. Learned counsel submits that earlier an FIR was lodged against mother-in-law, against accused persons, against three accused persons, including the mother-in-law, and that after the death of, and it is submitted in this context that after the death of the informant's husband, the informant's son, due to the informant's son, the informant falsely implicated the petitioner with these allegations. First, call for the case diary from the concerned police station. However, considering the entire aspects of the matter at this stage, and also the aspect of the 1 year child of the petitioner, It is directed that in the interim, in the event of our arrest, she may be allowed to go on bail of rupees 50,000 with one surety of the like amount to the satisfaction of the arresting authority and subject to the condition that she shall render cooperation to the investigation, appear before the IO for examination, shall not hamper or tamper with evidence. Please the matter on 20.
Obliged.
Short break, no? You will go? Yes, motion. to be made.
This is a revision petition against the order of the learned appellate court, Lordship, wherein the appeal of the petitioners were dismissed. Lordship. Kindly peruse the relevant portion of the order of the learned trial court, Lordship, page 57B, Lordship. (57B), Lordship.
Okay.
57B, Lordship, fourth paragraph. Accordingly, accused persons are sentenced to simple imprisonment of 1 year each and directed to pay fine of rupees 5,000 each, in total 20,000, in default of payment to undergo simple imprisonment for a term of 1 month under section 420(34) of IPC, Lordship.
This was the trial judgment.
This was trial court's order, Lordship. Thereafter, the appellate court order is at page, Lordship, relevant part is at page 74, Lordship. Paragraph 26, Lordship.
74.
Page 74, paragraph 26, Lordship. The impugned, Lordship, the impugned judgment and order dated 22/8/2024 passed by the learned Chief Judicial Magistrate Majuli in connection with GR case number so and so, convicting and sentencing the appellants, accused persons under section so and so, is hereby confirmed and upheld, Lordship. So 1 year imprisonment, Lordship. At this stage, Lordship, notice may be issued in this case, Lordship.
We are seeking suspension of sentence.
Lordship, that is in the IA, Lordship.
So can you?
We are on previous bail, Lordship.
Okay.
And then the next date is fixed on 1/7, Lordship.
Okay. So notice on the IA also.
Lordship,
Or
it
you
is
want me to
disposed of,
it can be
then
done.
notice is not required in IA, Lordship.
Stop. Mr. Bordel, learned counsel for the revision petitioner, who's invoking the revisional jurisdiction of this court, agreed by the appellate, the judgment and order. Judgment and order dated 9/12/2025 passed by the learned session judge Majuli as appellate court, whereby the judgment and order dated 22/8/2024 passed by the learned CJ Majuli as trial court in PRC 28/2022 within bracket GR 29/2022 was upheld, thereby confirming the conviction of the petitioners under section 420/34 IPC. Full stop. The petitioners had been sentenced to simple imprisonment of 1 year
Lordship.
and fine of rupees 5,000 each, in default SI for
SI for 1 month, Lordship.
SI for 1 month full stop, for their conviction under 420/34. How many petitioners are here?
Lordship,
One,
here
two.
2 petitioners,
Two
Lordship.
petitioners. Okay, full stop. Revision is not automatic, but you have some grounds. You think the how are you assailing the appellate order, appellate judgment? Because the revision, as you know, I will issue notice, but it's not automatic. You know, first appeal in criminals it's almost automatic, but revision you have some discretion. No?
Probably there
You
is.
have some discretion. Issue notice upon the respondents. Copy may be furnished to the learned additional people. Steps of notice. Whom have you implemented?
the person who is the complainant, Lord.
Complainant.
That is the informant.
Informant. Steps of notice by speed post shall be taken upon respond number 2 at the stated address. Full stop. Call for the original case records of both appellate and trial court from the of so and so, GR case number so and so, and the criminal appeal number so and so, from the court of the learned CJM Majuli. Must have gone back, so. Full stop. Place the matter in the orders column after 5 weeks.
Lordship.
After 5 weeks.
Before
No, to IS. The applicant petitioner has filed a criminal revision aggrieved by appellate judgment and order dated so and so, whereby the trial court judgment and order dated so and so was upheld, thereby confirming their conviction under 420/34 IPC. And the full stop. They had been sentenced under sentenced to so and so so on. Stop. This interlocutory application has been filed invoking section 438 BNSS, seeking suspension of the sentence and bail. Full stop. It is stated and submitted that during the trial, they were on bail.
Lordship.
During the trial and the appellate proceedings, the petitioners, applicant petitioners had been on bail. It is submitted that during the period on bail, they have not misused the liberty. I have given my consideration to the matter. Full stop. Considering the keeping in mind the nature of the sentence and the fact that there might not be immediate prospect of disposal of the criminal appeal. Full stop. It is directed that an exercise of powers under 438 BNSS 1 BS within bracket 1 BNSS. It is directed that the execution of the order of sentence dated appellate to 22/8/2000 appellate sentence dated 9/12/2025, confirming the sentence dated 22/8/2024 passed by the learned trial court shall remain stayed, and the petitioners are allowed to remain on their bail till the disposal of this revision petition. No need to file fresh bail bonds. Will you file? No.
Not required, Lordship, if it is suspended. Lordship.
The IA is only the sentence is suspended. All this conviction is sometimes,
Lordship.
as you know, the IA stands allowed and disposed of.
Oblige, your Lordship.
Third additional people.
before
May I please,
Yes.
Your Honor. Application has been filed.
Caution.
Processing of the FIR.
FIR.
FIR, yes. My lord, actually what happened, the petitioner as on today has been working as a criminal information officer to the National Bureau of Investigation. And subsequently, my lord, he has got an appointment from the Bloomington University of the USA. But unfortunately, due to some family dispute regarding their share of the property, and one FIR has been lodged, my lord. Your lordship will find the FIR at page 35. Page 35. It's a forgery case, my lord, as well as. May I read, my lord? With the reference to the subject cited above, I have the honor to lodge an FIR on the basis of our inquiry report on commission of the fraudulent activity of the forgery of the signature committed by Sri Ranjit Kumar Sharma, son of late Dibakar Sharma of 15 so and so Assam, and Sri Deepjyoti Bora, son of so and so, the proprietor of the Bajrang Infrastructure so and so, opposite to so and so, so and so. Here actually what happened, my lord, this forgery has been done by his Bajrang, this Rajan, Deep Jyoti Bora, my lord. Deep Jyoti Bora and Ranjin Sharma has not done anything. After that, what happened, searches have been filed and forensic report has come. It is established in the forensic report that this has been done by this Deep Jyoti Bora. That your lordship will find at the page 63, my lord.
Now, what are the allegations? Let us see
Allegation
the.
is forgery is the only agreement
Let
he
us
has
see
signed.
the.
Actually, they have.
Just a minute, let me read the FIR.
Yes.
Petition. Okay, the alleged to have forged the signature of the informant's husband, late husband.
Yes, yes. My lord, subsequently, what happened? This matter has gone to the forensic science laboratory. The forensic science laboratory, they have given a report, my lord. That report in a relevant portion is page 63, my lord.
The case is charge sheeted already.
Yes, he has been charged.
So, okay, then you are seeking quashing of
No, because
the
what
entire
happened-
proceedings.
Yes, yes, entire proceeding, because what happened, the forensic science laboratory has already given a report and it is established that he has not done the things. It is done by the builder. That is established. And he is now, matter is in before the learned court, my lord.
He's on bail.
He is on bail, my lord. Now, problem is he's getting,
Which page you want to show me?
oh, that
page?
is page 63, my lord.
63.
Page relevant portion.
Okay.
That is in below, my lord. 14.
Mhm.
63, result of the laboratory analysis, expert opinion, medical examination.
Mhm.
The FSL report collected on the report of the expert has opined that this is in the search sheet, my lord. The person who wrote the signature purported to be the Rajiv Kumar Sharma and specimen handwriting signature accused Deep Jyoti Bora are the same of the one person. So it is done by the Deep Jyoti Sharma, my lord, not by the applicant before your lordship, my lord.
They have been charge sheeted under what section? So probably
Yeah, search sheet.
conspiracy has been given. Conspiracy has been
Forgery,
given.
my lord. Forgery, that is the
Conspiracy has been given. Conspiracy.
420,
Conspiracy against
420
Kasim Ali. Yes, Kasim Ali.
471.
All the three have been
Yeah.
Kasim Ali and
420, 406,
468
468 and 471.
Ranjit Kumar Sharma.
Ranjit Kumar.
He was indicated as absconder, but in the meantime he
He
appeared.
has got the bail and your lordship may peruse the bail, that is on page 71.
So we will issue notice and call for the records and let them, the informant side appear.
Gotcha.
And then we can consider the aspect of this interim, this stay. Right? Otherwise, what is the stay of the case, stage of the case?
Your lordship may peruse page 71, my lord.
71.
Page 71.
Since he's on bail, there's no problem,
Yes.
immediate problem.
Page on 71.
The records come.
May I read matter, considering the nature of the case and the fact that the accused has appeared
No problem.
voluntarily today, and the accused is allowed to go on bail upon so and so, so and so, so and so. So my humble prayer is because what happened, the Bloomington University, they need a police report. Because proceeding is going on, and we are having also our High Court judgments, my lord. It is entirely civil.
No, that we cannot say. That civil, it may not say, it may not have it may have a criminal damage because the allegation is that forged the signature of her late husband.
Yes, my lord.
She's a widow.
Report has come.
So anyway, at this stage, we'll just issue notice and call for the records, right?
Yes, yes. And my
These
lord,
are NGOs, National Intelligence Bureau. These are NGOs.
kind of NGO, they have to
They
inform.
should not be allowed to take this kind of names actually, because we have a public institution called Intelligence Bureau. This is Government of India, Home Ministry.
Government of India, Home Ministry. That's
Crime Information Officer of National Intelligence Bureau.
Let the records come.
Let the records come. So, the learned counsel for the petitioner and learned additional people. The petitioner is aggrieved by continuance by a criminal proceeding by PRC case number 45 of 2024, which was registered pursuant to BIEO PS case number 10 of 2020 under so and so section. Full stop. The said case was registered based on an FIR dated 25/8/2020 with allegations of forgery and fraud with regard to certain property documents and construction of apartments. Full stop. The investigation resulted in a charge sheet dated 5/9/2022, and the case is stated to be pending presently before SDGM, learned SDGM S1 Kamrup M. The petitioner has appeared before the learned court below and has been allowed to go on bail/personal bond. Full stop. In total, 4 persons have been sent up for trial in the charge sheet. The issue notice upon the respondents. Copy may be furnished to the prosecution. The petitioner side shall take steps upon the respond number 2, speed post. The call for the scan TCR of PRC number so and so, comprising the relevant documents, such as case diary, FIR, charge sheet, and other relevant documents.
I am having a humble prayer. On the next date, my interim prayer may be considered, my lord, on next date.
No, not next date. After let the special.
Otherwise,
The prayer for stay of the proceedings. No, in any case, suppose he is facing a criminal proceedings, even they will have problems because you have to inform that university also.
Yes.
Even if
So that has been already informed.
stay may not help because the penance, because I know a case. Stay. But anyway, so
Because by the report has already come in the charge sheet also, that is clearly stated that the forgery is done by the builder, not by him. So unnecessarily, but he got.
but he's part of the firm, right?
No, he's not part of the firm. This is a conflict in between brothers, my lord.
He's the
A conflict in between brothers for the father's property.
Anyway, this is a matter of trial, but ultimately we have to see.
Yes. So that is why you are paying for the interim order. At least
Learned counsel, no, not stay immediately because he's
No,
on
it
bail.
is on the
Let it
next-
progress.
next
We'll see the
day.
merits of not necessarily the prayer for interim, the interim order by way of stay of proceedings is kept open. So on these matters are stayed, all these things get delayed.
Obliged, my lord.
In appropriate cases, there has to be stayed. The list after 4 weeks on a date to be fixed by registry.
Hearing be item number 22.
This is a lordship. But item 22 and 23 arising out of same FIR, same complaint, Madam, under the PRI. Let 23 be taken by senior will lead, Madam.
Sure. May kindly take after some time. Mr. Kyal is on legs. He will appear, Lordship.
Restart the matters.
Twenty-five.
Yes. On appears.
Here we have received a case diary. Here we have received a case diary, my lord. Here lordship may kindly produce the bail. He was granted interim protection on 21/5/26. Lordship may kindly produce the order, my lord. On that day, interim was granted only on the basis of for for his examination.
Exam.
Appear in the examination. Yes. And he was granted bail on 21/5 to 15/6 for his examination. But hereafter, in the case that after that he has appeared surrendered before the court or not, that information is not available.
Kindly see the viraling allegations.
Might.
That's respect. Kindly see.
Allegations, sufficient allegations are there against the present picture. And some of the documents also handed over by the informant to the IO also by them. Screenshot and other images by them. Again, he circulated the, and also from the
He is presently on interim bail.
present day. Interim bail up to 15 by 15.
For exam.
For example.
Yes, yes. Your Honor, thereafter, Your Honor, he said interim was extended by the court. And Your Honor, the accused person, they added about it. Yes. Last offense.
Last offense.
Yes. And Your Honor, the accused person is a 20 years old student, and he's studied and fourth semester of a electrical engineer. And Your Honor.
Then he should be
the
more
police-
responsible.
Yes. Your Honor,
He
police-
knows everything by them.
Anyway, just let me see. Well, I'm only concerned about this otherwise viraling aspect.
Right.
Because those are very serious matters
Your
actually.
Honor, Your Honor, accused person is a first time offender, and Your Honor, he is 20 years old.
Just-
The bail objection itself later, but it was that he used his mobile phone for operating my Facebook account, our Facebook account.
The interim bail was still which date?
Your Honor,
Up to
15/6,
15/6. But here it was extended.
Yes, Your Honor. And the Lordship, the police
no
got
order
a
is
sufficient
there.
time, Lordship, for inquiry, and the Lordship, the father, custody is not necessary, Lordship. Because Lordship, considering his academic career, Lordship, he may be allowed to go on bail. And the police arrested him 12/5/2026.
183 statement, my lord.
And the Lordship police got a sufficient time.
Oh, very long. You can keep submitting also. What is the finding have you found in the
Here,
investigation?
my lord, some of the, my lord, mobile screenshot and other, my lord, file photos were submitted to the IO, my lord.
Improper photographs?
My lord, notes in the kind of the pin dash, my lord, star mark is there, my lord, in the flag mark, my lord, star, last portion, my lord. And FSL report is not yet received, my lord. Including WhatsApp messages, photos and messages.
Yeah, you're right.
Not the police got a sufficient time for investigation, and the lordship is a further custody not necessary, lordship, because lordship affair was lost on the 10/5/2026. So lordship already police the investigating the matter and the sufficient time is received by the police.
So and so.
He was arrested on 12/5.
21/5. Huh? Para 1, para 3, para 4. Full stop. To enable the next paragraph, to enable the petitioner to appear for his exams, this court by order dated 21/5/2026 granted him interim bail. Interim bail till 15/6/2026, which is extended till today. Full stop. It is subsequent. No, stop. In the meantime, the case diary has been received. The learned additional PP. The learned counsel for the petitioner submits that the petitioner is a student aged 20 years and that he denies the allegations. And pursuant to grant of interim bail, he complied with all the conditions incorporated therein. Full stop. It is also submitted that police has got sufficient time for investigation. When was he arrested originally? 12/5.
12/5.
Or sufficient time for investigation, and his further custodial may not be necessary. The learned additional PP, Mr. Sharma, submits that the IO has filed a bail objection and that investigation has revealed a lot of incriminating matters against the petition. An electronic material object in the form of a pen drive has also been seized, purportedly containing screenshots of the victim's images. Full stop. I've carefully perused the bail objection, in which IO has strongly objected to the grant of bail, alleging that he has been continuously harassing the victim girl, uh, uploaded her personal phone number in an improper manner to expose her to disturbance from improper quarters, semicolon, has created fake social media accounts and uploaded her personal and private photographs. Full stop. I perused the statements of the witnesses and the other materials available in the case diary, including the grounds of arrest adduced by the IO during investigation. Full stop. The statement of the victim girl has been recorded before magistrate. She's indicated her age to be 20 years. In the elaborate statement, she has made allegations which lend support to the contentions in the FIR and the objection of the IO. Full stop. She stated about continuous harassment, stalking, and disturbance. Full stop. She has also stated about uploading of her personal number in an improper manner for disturbance on people. She has also stated about viraling of her photographs through fake social media accounts in her name. Full stop. The statement of the informant has also been recorded. Full stop. The informant is the father of the girl, and he has also stated about continuous disturbance of his daughter, uploading of her photographs in improper manner, as a result of which his daughter is stated to have become highly distressed and disturbed. And the investigation has progressed, but it's still continuing. Full stop. In the given facts and circumstances, I'm of the considered view that there's no sufficient merit in the prayer for bail at this stage. Full stop. The interim bail was granted only for a limited purpose of enabling the accused to appear for his examination, which he has done so. Full stop. Accordingly, in the given facts and circumstances, the interim bail granted by order dated 21/5/2026 is hereby cancelled, and the instant bail petition stands rejected at this stage. Return back the case there. He'll have to surrender. The petitioner shall surrender before the learned court below, the jurisdictional magistrate court, within 7 days.
All right, okay.
Can't help it. Lot of materials.
26.
Yeah, please, Your Lordship.
Yes.
Lordship, the petitioners are booked under section 21C and 29 of the NDPS Act, and they are arrested on 21/6/2025. Now, Lordship, I am pressing this bail application on the ground that there is total non-compliance of section 48 of the BNSS. Lordship, along with this, the arrest memo, that is section 36, has also been violated because the arrest memo does not bears the attestation of any witnesses. Collectively, Lordship, there is violation of the provision to inform any of the friends, relative, or nominated person, that is section 48.
Yet notice is not there.
Not there.
Before starting my colleague, my lord, it is a voluminous, my lord. I will have to go through at two, my lord. That I think set through.
Lordship,
Only see the first,
my
see
lord,
that
my
aspect.
lord.
coordinate bench already granted bail to one of the co-accused.
In all these serious cases, and in all these serious cases, where in the present times, where these infirmities are there, that notice is not served, signature is not taken, we'll give a direction to the concerned SP to seek an explanation from the IO as to why he has not done so. Okay, this is necessary. Okay, we'll take it after some time. Okay.
Lordship, kindly
Yes.
take it after.
After some time. Okay, no problem. Yes, Mr. Mehdi. So much.
Lordship, they filed,
May also take this matter after some.
After some,
they have filed the objection and we have received.
finish other matter.
Right, Lord. Regular application Lordships, this was behind the bar for last 47 days, Lordship. 6 days offense, Lordship. FIR is at page, my lord, page 17, my lord.
Cattle preservation.
Yes, Lord. May I read the FIR, Lordship? It is Barnacle, Lordship. এজাহাৰকাৰী বিধ কেৱল এই যে ইংৰাজী 7/5/2026 তাৰিখে নিশা অনুমান 2 মান বজাত মোৰ গৰু গোহালিৰ পৰা নিম্ন বৰ্ণিত ধৰণৰ দুটা গৰু আৰু ওচৰীয়া আমছেৰ আলীৰ পিতা হাইদৰ আলীৰ ঘৰৰ এটা গৰু গাই গৰু অজ্ঞাত চোৰা চুৰ কৰি লৈ যায়। ৰাতিপুৱা উক্ত ঘটনা গম পাই বিচাৰ খোজাৰ কৰি খাৰুপেটীয়া থানাৰ অন্তৰ্গত নেপালী বজাৰৰ পৰা নিম্নলিখিত প্ৰতিক্ৰিয়া গণে বাকী প্ৰতিক্ৰিয়া সহযোগত এটা দমৰা গৰু আৰু এজনী গাই গৰু মাইলত স্লটাৰ কৰি কৰে আৰু এটা ওচৰত বান্ধি ৰাখে আৰু আমি স্থায়ী ৰাইজৰ সহযোগত আটক কৰাত প্ৰতিক্ৰিয়াগত পলাই যায়। Here, my lord, I am not named in the affair, and my lord, police arrested me by stating that I am the affair name accused person. Kindly see page 21, my lord. This forwarding report in the vernacular.
Copy paste.
Page 21, my lord. Gaptar.
We have to be very careful.
My lord, Gaptar 50, my lord. CL number 4, my lord. অভিযুক্তজন এজাহাৰত নাম থকা অপৰাধী. Whereas, my lord, my name not in the affair, my lord.
You are not named in the affair.
Police wrongly arrested me, my lord.
Anyway, so
Second part, my page.
grounds of arrest.
Yes, my lord. Secondly, my lord, CL number 5, my lord. My lord, অভিযুক্ত জনক বিএনএছৰ আণ্ডাৰত 35 নোটিছ জাৰি কৰিব পৰা নগ'ল কিয়নো তেওঁক নোটিছত এৰিলে বহিৰাজ্যত পলাই যোৱাৰ সম্ভাৱনা আছে, my lord.
I've read this.
Yes, my lord. Even my 35 notice also not issued to me. I am arrested wrongly because police thought that I am my name in the affair, but my name not in the affair, lordship. And I am 47 days behind the bar, lordship. And my lord, kindly see,
They've mentioned him as a habitual thief who transports cattle. Anyway.
Well, I am the driver, lordship. I am the driver. I am the bolero vehicle driver, lordship. 47 days, my lord.
We'll see that aspect. Anyway, we'll see that aspect. And the diary has come.
My lord, diary received, my lord. From the diary itself reveals that he is the transporter of the, my lord, transporter of the, my lord, cattle, etc., my lord. And on that occasion, on that day also, when police and other person appeared, my lord, seized the cow, my lord. Some one to our, it is slaughtering, my lord. And that cow also he is transported, my lord. On that day also, my lord. Here, lordship, kindly produce only 2 statements. And on that day also he was arrested, my lord, when he carrying one cow, my lord, in his vehicle, but he failed to produce any documents, my lord, regarding that cow.
This statement and
My lord, not that is the IO note, my lord, they have a statement, one statement, my lord, it will be clear, my lord.
Julhas Ali.
My lord.
47 days, my lord.
What if I'm not yeah. What is his name? His name?
Profitically, lord.
Rafiqul Ali. The materials to indicate that he was involved in the theft of this. He was transporting the stuff.
My lord.
I am a driver of bolero car, lordship. So, my lord, my duty to carry, my lord, when my lord hired my vehicle, lordships. And my lord, I am been for last 47 days, and my not even name in the affair. Police arrested me. Police thought that my name in the affair, my lord. And even 35 minutes also not issued to me, my lord. And it is written in the my lord forwarding report, lordship. Kindly consider 47 days, my lord. And my maximum period, my lord, my minimum 3 years, my lord, and maximum 8 years, lordships. Minimum 3 years punishment, lordships. And all the 3 cows which are alleged to be stolen, my lord, recovered, my lord.
Recovered.
Recovered,
How
lord.
is it?
One of the slaughtering.
Oh, yeah, one was slaughtered.
One recovered, my lord,
In the affair,
in condition, my lord.
in the slaughtered manner, only recovered, my lord. In the affair, itself mentioned, lordships.
That is not recovered anyway.
My lord.
Learned counsels for the
You
petition.
has also placed some
and
objection, my lord.
Additional PP for the state. Full stop.
Only 47 days, lordship. Years punishment only, my lord.
Petitioner is seeking regular bail under 483 BNSS in Dalgaon PS case number 73 of 26 under so and so section. Full stop. The informant alleged in the FIR that on the previous night some miscreants stole cows from his cow shed as well as that of another person. Full stop. Several persons were named in the FIR full stop, as being involved in the incident. Full stop. The learned counsel submits that the petitioner was arrested subsequently, and in the forwarding report he is mentioned as FIR name, though the name does not figure in the FIR. Full stop. I perused the forwarding report. That's correct. Forwarding report. Full stop. The learned counsel emphasizes that he is a driver of a Bolero pickup truck, and that he has already spent 47 days in custody after being arrested in this case. Full stop. The case diary has been received. The learned additional PP. Case diary has been received along with a bail objection. The case diary, the learned additional PP submits that the petitioner has been found involved in carrying some cows illegally, including the stolen cows, including the stolen cows, as revealed from the statements of some of the witnesses. I perused 2 of the statements placed before me along with the case diary. Seen the progress of investigation. There are some incriminating materials against the petitioner. Nevertheless, considering the progress of investigation and the length of detention, he is allowed to go on bail at this stage of rupees 50,000 with one surety of the like amount to the satisfaction of the concerned learned court. CGM Gaurang Mohalda. And subject to the conditions that he shall cooperate with remaining investigation, not hamper or temporary dividends, shall not commit any acts violative of some Cattle Preservation Act. Violation will entail cancellation of the bail, return case diary.
I am big right.
I can have 30 and 31.
30 and 31.
Here in this matter, well, I am behind the bar for last 55 days. The FIR at page number 7. The allegation is that, my lord, one vehicle was intercepted by police, my lord, and on interrogation, those persons have admitted that they are involved in immoral trafficking. That is the case, my lord, and I was the driver of the vehicle which was intercepted. As per the FIR itself, my lord,
Yes.
during no such act, my lord, we have been arrested, my lord. I have been arrested, my lord. The vehicle.
Baharul Islam is one of the persons
My lord.
named in that.
My lord. Already 55 days, my lord, apart from merit of the case, my lord, I'm praying on length of detention, my lord.
Like,
55 days.
okay, I understand. Did I read this? Three of the individuals pending. Okay.
Pilot, we received the case there.
Arrested on
Pilot,
Arrested on 2/5.
2/5.
minor.
Minor 55 days.
Case there results minor sufficient incriminating materials against the fall of the petitioners minor. Two petitioners are here minor.
Mhm.
Baharul Islam and Zainur Ali minor.
Mhm.
Here is the minor main supplier of the minor cars to the customers minor. They are doing the business for a long time minor, and it was for those who were provided in the WhatsApp minor. Thereafter there is a minor also supplied the minor. This is the allegation against the minor. Is very serious in nature minor. And Lordship may kindly please 183 statement, one of the 15 minor. He will say everything minor. And their involvement is there minor. Lordship may kindly please the 183 and other statements minor. It is not the case of bail at this stage minor. And they have also decided in which hotel they will stay minor, that part also. Lord. How they were exploiting the minor victims.
Yes, yes. Luckily, they were apprehended.
Other statements are there minor.
Mm-hmm.
Other statements are also there minor from the co-equities also minor. How they have planned.
It's true. Anyway, he may be, in prosecution may be right. So, investigation, let it be completed. Anyway, heard, learned counsel for the petitioner.
143 is there minor.
Trafficking.
Minor. 143 is there.
Hatigao PS case number 84 of 2026. Arrest on the so-and-so section, arrested on 2/5. The case arose out of FIR dated 1/5/2026, lodged by police official of Hatigao PS. The gist of the allegation is that source information was received about activities of flesh trade, and subsequently on that day, in the late wee hours of 1:30 a.m., one vehicle, a swift vehicle was apprehended with 4 individuals, including the present petitioners. On subsequent investigation and interrogation revealed that it is alleged that our subsequent interrogation and investigation revealed that they were transporting. They were indulging in these activities of immoral trafficking. The learned counsel fairly submits that he's seeking bail more on the length of detention of 55 days rather than merits of the case. The case diary has been received. Investigation is not yet completed. The learned additional PP submits that learned additional PP supporting the bail objection of the IO submits that there are sufficient materials, and the statement of one of the victims recorded before learned JMFC may be perused. And it is submitted by the prosecution that it's not a fit case for bail at this stage. The statement of one of the victim girls stated to be aged 25 years is available, was recorded before the learned JMFC under 183 BNSS. I have gone through the said statement in which she stated about approaching one of the accused persons for her financial crisis and for seeking a job, whereupon she was tricked into immoral trafficking and exploited. This is also alleged that she was also blackmailed into servicing the persons, servicing the clients, failing which they threatened to disclose her private photographs. I find force in the contention of the prosecution, and therefore the bail petition stands rejected at this stage. Return back the case to. He needed money for the paralysis of her brother. These are the human tragedies. Actually. So, anyway,
31, my lord,
same.
one thing is there, my lord, victim girl, which was,
Almost same.
Same, my lord. In the earlier, my lord, same victim was arrested in another case, my lord. So perhaps, my lord, so far, my limited knowledge is concerned, my lord. I have a.
I'll see it again.
I have a next, my lord.
Now, this I have dictated for disorder actually.
In another case, my lord, earlier, few days earlier in 2023, another.
January's FIR name in the same case.
Yes, my lord.
84, Hatigaon 84.
In earlier case, my lord, there is another case in 2025 in Tispu police station, wherein, my lord, although not.
He was granted bail.
No, that's not, I'm going to submit, my lord. Although there are no FIR named accused of the present petitioner, but the present petitioner and the alleged victim girl of the present case was arrested in this case, my lord.
Yes.
And perhaps.
He was also arrested.
Yes, my lord.
He was also arrested.
In that case, they are friends, my lord. And as the petitioner was arrested in another case in earlier, my lord, therefore they are coming from a party, my lord. And if my limited knowledge is concerned, my lord, perhaps, my lord, 143 section is incorporated, but so far the FIR content of the FIR, my lord, 143 and section 2 may be applicable. And in that case, my lord,
Whatever may be, my lord, that is the matter of trial, my lord. But here.
That case it will be 60 days.
60 days, 56 days.
So now no, still they'll get if that is so, then they'll get statutory bail. But anyway, from my former statement, that story is not borne out. It appears to be a out and out case of exploitation and traffic. But anyway, so we'll see. Okay.
Dispose of.
Same order. Same order. ठीक है सर? इसे ना तो divorce of it. Okay, after lunch.
Two.
POCSO matter.
Section 76 of the Act, which is assault or use of physical force to destroy. And the punishment.
List khonde bone.
Offenses are 7 years.
Yes. You have to appoint someone. Then when today it don't be possible. If the amicus is available, I can 30th or 2nd I can list. Amicus or list khonde. But I don't know who will be available, who will not be available. It is submitted by the learned additional PP, Mr. Bothakur, that service has been completed upon the respond number 2/informant system. However, as none is appeared, ... learned counsel is hereby appointed as amicus for the amicus to represent the informant. Full stop. The learned amicus may be given a copy of the notice. At least the matter on 2/7. So I'm keeping it blank, huh? Just whoever is available on that day. You want it on 2 for 30. So again, I think date also you should keep it flexible, because depending on availability of the amicus, because many people may not be available. I'm keeping the date also. If he or she is available on 30th or 2, we'll adjust accordingly. Huh? Don't worry. Just find out. You're gonna say date to upon flexible faculty. Scan TCR is available. Yeah, no, I have kept it because availability is the question that you have to find out. Can you help him? Can you help him? Whom to appoint? Because person may not be available. Will he be available? And that's why I'm keeping it open. You just find out. I'm keeping it open. You can? Okay, he'll be there. FOC. Then which date will be convenient for you? 3 strike. FOC. Mrs. FOC.
I agree.
Yes, Ms. Lam.
And eventually the relationship turned over mother. Some allegations that the petitioner must opt the photos and videos and were circulating. There might be some photos and videos, but when the relationship was cordial mother, photos were of that era. These are not subsequent photos or videos. There is some eventually relationship and hence which case and the one for 40 days in custody matter. The 60 days of custody matter.
Okay. First. Morphed. They've seized a pen drive. Forensics. Okay, you can submit. Hmm. Yes. Oh, oh, sorry, you've completed. I'm seeing this. I'm seeing. Hmm.
That might be allegation, if relative in that core very big problem. As far as whether this is a found anywhere much. I might actually deal for 40 years, investigation had, everything has been completed. Further custodial interrogation must be required. If there is something unpaid, right?
Okay.
And if nothing else is
Hmm. Send to forensics. Forensics. Oh, viral. Yes. Yes, please continue. Hmm. Hmm. No, just. Sam Abdullah, learned counsel for the petition. You are Mr. Mondal. It was first. The petitioner is seeking regular bail in connection with Sangsari PS case number 116 of 26 under so and so section. The gist of the allegation in the FIR dated 18/5/2026, lodged by the father of the alleged victim girl, is that she is aged about 17 years, and for the past few months, the accused petitioner, has been harassing her and creating more photos and videos of her and circulated on social media. As a result of which, the informant's daughter suffered a mental breakdown. Full stop. It is also alleged that he disturbs her in front of college and threatens to throw acid on her body. Full stop. The petitioner was arrested during investigation on 19/5/2026 upon registration of the case. The Mr. Abdullah learned counsel submits that he has already spent 40 days in custody, and though allegation has been made in the FIR about viraling of photograph, whether the IO has seized any such materials during investigation. Full stop. it is submitted that the petitioner and the alleged victim girl were in a relationship earlier. And after the soaring of the relationship, the case has been lodged, making false allegations. The case diary has been received, full stop. The learned additional PP submits that there are incriminating materials lending support to the allegations made by the girl's father as informant. Full stop. The police has also seized electronic material evidence and which is sent to FSL. Full stop. The informant has entered appearance and filed a written objection supported by affidavit, a written objection on affidavit, objecting to the grant of bail. Full stop. Mr. Mondal, learned counsel for the petition, submits that mock videos and photographs have already been made viral by the petitioner, and that he has been harassing and threatening the girl over this period. Full stop. I have cleared the relevant portions of the case diary. Full stop. There's some other. Full stop. There's an other cases. No, it's okay, no problem. Here is the note of the IO about extraction of videos, photographs, and other materials from the seized mobile phone, purportedly of the petitioner, and that the same has been processed for forensic examination. Full stop. The informant in his statement has reiterated the allegations. The statement of the girl was recorded before police as well as before learned JMFC during investigation. In both the statements, she has stated about the harassment and constant stalking by the petitioner. Full stop. She has also stated about the viraling of her private photographs, private and improper photographs, causing great distress. Full stop. On the materials, including the statement of the informant as well as the girl, apprehensions are indicated about her safety and well-being. Full stop. In the given circumstances, the bail petition stands rejected at this stage. Return the case there. Okay. Oh, yesterday's matter. Yes, that day we had heard, no? This much. Yes.
This was drafted on page.
Yes.
Let's come to page 38.
Yes. Not again.
The operative portion is at page 40. Upon consideration of this.
Page 40.
Yes. It's a third subparagraph. Upon consideration of the submissions made by this party and on perusal of the affair, it is not discerned as to why standard not examined by the of the affair with the inspector of police of the body. When other so-called victims were examined, after they had given information as it was simply stated that petitioner had left in place after completion of examination of the so-called victim. Other the statement based by the itself of the prosecutor also the statement of the poet. Considering the facts and circumstances of it, provided that petitioner made above in event of arrest shall be released on bail. When I went to the police station to give my statement, my lord, I have been arrested. My humble submission is an absolute given unlawful arrest. If
This was when this case was regarding allegations of robbery.
the four persons
in it.
lodged an FIR, the Jalpari PS,
Yes.
said they have been robbed by some people impersonating themselves as a crime branch people.
Okay. Yes.
Eventually, my lord, that information turned out to be false.
False.
Those 4 persons were, my lord, arrested
Mm.
and subsequently they were released on bail.
Mm.
Now, the present petitioner along with another person, according to the FIR, that FIR, were also there.
Right.
But, my lord, we have absolutely no connection. Therefore, my lord, we were granted anticipatory bail.
Mm.
Now, when we went to the police station on 19, my lord,
Mm.
I was told that today, on that day, they were busy with the Lord, the Shamikha thing.
Mm.
So therefore, they said, please come another day. Then they went on 21 because High Court gave 7 days time to record the statement. On 21st, we have been arrested in another case. So I got absolutely nothing to do with that case. Now the Lordship proved the law as later on by the Supreme Court in Uday Chand. If on the date of enlarging me on bail, any other cases are pending against me, that should have been informed. The Lordship should kindly have this.
True. So this case, the allegation is different.
Case different, Lord. And in this case, there's other case was there, my lord, where my lord, the person has been given Jima also. That
Mm.
order we have brought.
Mm.
Please have the judgment for a moment, sir. Please come to para 5.
Mm. Mm. This is the original decision, right?
Yes.
There's another, in recent times, yeah, it's a recent times, there's another, it has been reiterated, but I'm
Yes.
forgetting the name.
And now, it also passed an order based on Uday Chand.
Oh.
And it's an authority for the proposition. That if on the date of enlarging somebody on bail, another police station case is pending,
Mm.
then it is the duty of the Lord police to
Mm.
inform the
Mm.
court. Then court will say, in the event he is required in any other case, he may be arrested also, or maybe not be released. Now, my lord, in the other case, that is the Lord Jimana.
Okay.
Well, everything is recovered. So, my lord, this is an absolutely abuse of the process of authority, my lord.
Mm.
Where is the scope of arresting in that case?
Mm.
And I don't think there is any necessity of CD in this case, my lord. Because in that case also, that was a case of the alleged theft of, my lord, cattle.
Cattle.
And now, my lord, there were 8 cattle and those have been recovered.
Mm.
And they have been given to the Jima of the owner because they could produce materials to show that they bought it from the Bukalgo market. So, my lord, magistrate has recorded that as that order in that order giving Jima to the owner.
Mm.
So, my lord, when in that case, the person who has bought it has made a statement before the police, where is the question of that those cattle being stolen goods?
Yeah.
Therefore, I'll humbly pray the Lord. Then abuse of the process of the authority, therefore, I should be enlarged on bail. Whatever condition Lordship puts, I'll abide by that.
Mm. When he subsequently went for the recording of the statement, he was arrested.
Yes. On 21/6.
You could get the case diary.
Yes, case diary received. Case diary received, my lord, regarding the.
Yes,
case,
anything else?
19 numbers of cattle, 2 my lord pickup vans were seized and recovered by the police on on FIR registered on 13/6/26.
Mhm.
It is not that, my lord, prior my Udoisan case is not at all applicable because in the earlier case, my lord, petitioner was granted bail on 12/6, my lord. And case was earlier, present case was registered only on 13/6/26, my lord. And regarding the materials, my lord, yes, only, my lord, at this point of time, only the statement of the co-accused persons. That, my lord, these accused persons are involved in dealing of cattle, my lord. 4 accused persons were arrested along with the 2 vehicles, my lord. And from that vehicle, they were on that day transporting, my lord, in a very cruel manner in those vehicles, my lord. In one vehicle, my lord, 9 numbers, and in other vehicle, my lord, pickup van, 10 numbers of vehicle. And those 4 persons arrested, and those 4 persons, my lord, named the present accused persons, my lord, that he is, my lord, involved in dealing in the.
Actually, the sequence of events in which he got arrested
Yes,
obviously gave rise to
but
you
yes,
know,
that is
his
the
grievance.
that is the problem here.
That the
But
statement should
regarding-
have been recorded, and when he went to record the statement, he was.
Yes, otherwise only for, but Udoisan is not applicable because the.
Yeah, maybe technically, yes, maybe. But so anyway, so you submit the case diary. I will
Yes.
pass it. Pass that today itself. That is the issue. Short issue.
At this point of time, yes, only co-equals.
Yes, no issue. That's it. You want the gym order, or I'll return it.
That the 9 cattle has given to owner.
Investigation is going on.
Time constraint আছে ন? মই পিছত কৰিম, simple. Time constraint আছে ন? Chamber.
And regarding my lord, criminal antecedent, my lord, that case number, my lord, in the first page, my lord.
Okay.
there mentioned.
I'll see. এটা অলপমান এইকেইটা আছে ন, সেইটো চিম্পল কৰি দিম। একেলগে মই কৰি দিম আছে গোটেইখিনি।
Supplementary 59.
Busy আছে নি?
I am behind the bar, 1,100.
Oh, so that case, huh?
Driver is given,
Okay.
1,000 today, and when I take today, who tried was even not completed.
I remember.
Few days you are were examined, but cross is done. What witness was came for cross, while he has given evidence, he was taken to the custody, that you are speaking false now. Because there is another proceeding against that PW one. The other witnesses are out of fear not coming. And one into me a murder, which is one co-equal, still one marriage is going on to trace him out. Then murder, there you got to find the three witnesses. They did not support two, one is their own confidential witness, but other two has not supported the case. One has taken into custody, there is a separate proceedings for false evidence. Then murder you got to find from their own or evidence also you can take establish the matter. Then murder, if the co-equal won't come, how long I will put her behind the bar without trial? Since 23 we are behind the bar. Now on this point, my lord, you got to find it is reflected in page 3, can you come to page 3?
Page 3.
Page 3 of the petition. The recovery of 47,000, number of 47 kg of suspected methamphetamine and methamphetamine tablets estimated to be valued at certain amount, and number of but my lord, in the first number, they have mentioned it as a cannot.
Okay.
Kindly peruse the
47 crores values, market value
Yes. Arrest me, I take you also to arrest me,
at page.
please.
Pani value.
We have taken 16 the code below, the 36 has not been complied. Page 60. Kindly come, my lord, page 60. Regarding arrest memo below.
Hmm.
You want to call it?
Yes, sir.
Now, this is the arrest memo, my lord. Long where. Arrest memo, this is the arrest memo. Up to 61. Page 60.
Name of the accused is
Yes,
Pintu. Pintu Dev Burma.
yes.
No, Dhananjay Burman.
There are 2 persons there.
Two persons. Is Sajid Paul there?
So, my lord, in this 36, my lord, there is no mention of anything, but my lord.
No, 36. What is the infirmity? Not 36.
36 has not been followed.
No. What is the infirmity? What is the infirmity in 36?
It's not proper, my lord.
I've seen, no, there's no signature or witness or, no, I've taken,
Yeah.
but,
Two preeminent witnesses, those have been cited as witnesses in this case, my lord. Now. Cited as witness. Then my lord, your should find it in page 30. Kindly page 81, my lord, kindly come, page 81.
yes.
Page 820, accused Dhananjay Burman and Pintu Burma are produced from judicial custody.
Hmm.
So VC, they are remanded back to judicial custody. Till 25 to 26. One PW named Vishnu Pal is present. He is cross-examined by defense.
Yes, yes, sir.
From parallel of the evidence adduced by the witness, Vishnu Pal stated that in his examination in chief, said witness clearly stated that he was present during the search operation. And the CRI official start in presence of and recovered suspected narcotic or drugs from the same chart. The same witness in his examination in chief also stated that he took photographs and photo of the search operation. Today in his cross-examination, the same witness stated that no search was conducted in his presence and he did not witness the search operation. He also stated that the DRI officials did not show him the seized items and the vehicles was not searched in his presence. Both these statements cannot be proved, and therefore it is clear that either the witness received far that both falsely in his accusation and attempted to implicate the falsely, or he has both falsely today during his cross-examination and attempted to save the accused. And therefore, it is a clear case of adducing false evidence
Yes.
in the court, as both situations cannot be happening at the same time. Accordingly, for adducing the false evidence in the court, it is a criminal offence. CAO of the offence is directed to all the FIR against the witness Rishis Pal. Witness Pal will be present in the court today, immediately taken to custody and handed over to the police for doing the needful as per the provision of law. So the PW one is the own man. He was the freest man at the time in the chief.
So the both statements cannot be true. No? One is he said A, and then A is B, and in the cross-examination he said B is A. So one of them is false. So anyway, so people, of course, he has to be properly briefed by the prosecution to understand the implication of the statements. But anyway, this has happened.
And this man was signed in the arrest memo, long arrest memo, where the particulars were not there.
Biswajit Police.
So my for evidence, it is still lying cross-examination for other person. They are not obtaining from you. My lord, I take the lordship, I give my evidence portion. I know the informant, I know the accused person who are present.
Where's the page? The report. It is here. Is it here? Should be in the record. Okay. Many unnecessary parts also come, voluminous. So that's why I try to specify.
Yesterday, Lordship,
Sometimes it helps like.
Lordship,
Hmm.
I couldn't find 48 notice, Lordship.
48 years have not followed.
But
You could not
Lordship,
find.
It's also not there.
but Lordship,
What is happening is also violating.
Just
grounds of arrest was intimated through over phone, Lordship.
Over phone.
I have received.
so anyway. So let us. You can complete for the deposition of PW with a name. Keshav Dev.
He said, I know the informant, I know the person who was present until in the court today. The occurrence took place on 7/9/23.
Okay.
My lord, the lordship got it. Then my cross, what is said, my lord? Cross. I do not remember the date of occurrence. I also do not remember when the occurrence took place. I deposed in 7 MBBS cases as witness on behalf of the DRI. The DRI officer called me to come to DRI office at Rangpur, as one of the officers was known to me. DRI officer took my signature on various papers. The content of those documents were not read over to me. The statement of the accused persons were not recorded in my presence. My statement was not recorded by DRI officer.
No.
This is the evidence in cross. So where 1 and 2 goes, Even third one is official.
He has diluted his evidence, obviously. He has diluted.
48 is not followed, 47 was also not followed.
Diluted his evidence.
No trial, my started my till today.
Anyway, so
Regarding trial, my detention.
the one witness has been sent to custody.
Yes.
Good in a way, because coming to the court and lying through your mouth, it's not fun. Court is not a game that I'll come and say as a witness whatever I want. As an adult, if you speak falsehood in court, you should be prosecuted straight. That is why, you know. It's, anyway, so okay. No definite case law has emerged on that position actually. It should. No definite position of law has emerged that how much detention would be considered to be violative of Article 21. Yeah, in that case, another case, 5 years also was not given.
3 years.
So that means 5 years is also not been taken as a violative of, in a way. But so it's emerging. In some cases it has been considered, in some cases not. So definite, depending on the facts now. So on as a principle, it has not emerged. It will emerge probably in the future. So this one
Because of wrong details, just right.
there are on facts there are several decisions that we can have.
That is my only.
For the moment we can use that perhaps. 1 year, 7 months also. He has been.
One 1,000.
Yeah, that's more than 3 days since 2023.
Yeah.
That is there. This we can see. Yes. On individual facts, there are several decisions. Yeah. Period of 1 year, same.
Failure to conclude the trial within a reasonable time, resulting the failure of the prolonged investigation and militates the against the procedures, precious fundamental rights granted under Article 20 of India.
What is reasonable time is the question actually.
Embarking, forwarding the statutory embargo created as Section 561 B of India Act is such circumstances be considered. That is my word.
This repeat, same. No problem.
Then one Lokira, our own High Court.
You please submit.
Driver, it is my lord, my honorable Justice Parpakur, that the driver cannot be, because he was coming with the risk pilot. And my lord, he had no knowledge of this.
No, that cannot be generalized. It depends. It cannot be generalized.
My lord, since 48 has not been complied as per their.
And that I'll see.
That is, and long detention without trial. Witnesses are not supporting the case. And after fear, other witnesses are not coming. Now at this situation. And one going to it is yet to be arrested. They are sending non-valuable warrant, non-valuable warrant against him. Under any condition, I will pay the trial matter till the end. Though I am from Tripura, matter any condition.
So I have a submission, Lordship.
Yes, I'll hear you.
Here, Lordship.
I'll hear you. Of course. I'm coming to you only now. Yes. Please.
Lordship, here, Lordship, 47 kgs of methamphetamine tablet was recovered from the position of the petitioner, Lordship.
Market value is stated to be 48
47 crores.
crores. 47 crores. Yes, yes. It can be. Tremendous money. Drug trafficking. Tremendous.
Much more than commercial quantity, Lordship.
No, that monetary value is like that.
47 crores. Lordship. And Lordship, I have received information that Lordship, 3 witnesses have been examined out of 5. Only 2 witnesses are remaining, Lordship. Trial is at the fag end, Lordship.
But I'm just concerned about 48 is no compliance.
I didn't find Lordship 48.
Then it will be difficult.
But it was grounds of arrest was communicated
Hmm.
over phone.
Over phone. That may not be sufficient.
And, which was
It was in
acknowledged by the-
2023, no?
Yes, Lordship.
Oh,
And
that
which
no.
was acknowledged by the accused person, Lordship. I have submitted.
23, they were not expected also to know all these things.
And Lordship, I'm relying on judgment. I have marked the para, Lordship,
I'll see.
from point number 15 to 21, Lordship. Lordship may consider this judgment.
Yes, this application is not uniform, so there's a. Yes. What is prolonged incarceration for the purpose of bail has not been expounded by this court. That's been said. So that's my point actually. It will happen someday, maybe. As of now, we have to use those different facts and circumstances, judgments.
Yeah, I have submitted one more judgment, Lordship, pairs of 10 and 15, Lordship. This is regarding the violation of 21.
Yes,
Lordship,
that's all.
Lordship may consider these two judgments, and I
I'll
have submitted one more judgment of coordinate bench, Lordship.
Okay,
There,
I've
Lordship,
seen.
he was behind the bar from last 4 years, bail rejected, Lordship. That judgment may be considered, Lordship.
Some uniformity will help no, on this point. Actually, in my see, we can think like that. It can be a combination of that formula, combination of your number of witnesses, prima facie materials, and the sentence. You know, suppose a 3-year sentence. Person is already in jail for 1 year. That's a very unreasonable period in a sense. No. So I'll see. The various facts it's emerged. So maybe absolute for period may not be possible, but a broad guideline may be possible. It will reserve, it will not reserve, chamber, I'll do it.
60.
Itu কোনটা আছে না ওটা 15 না? 15 এটা
15 আছে, এটা 61.
61
এটা
তাৰপিছত কি দিব এই দুটা দিব নে তাৰপিছত just a minute.
heading 30 billion 40.
EB. Oh. Yes. Hmm? Yeah. Thanks to the public prosecutor, sincere. FIR at page 12. Please.
Section 123 and section 71.
Neighbors.
Have you seen how I forcefully put some liquid substance from this bottle in my mouth and put in the jungle? And my petitioner himself went to the police station to make a query that on 9th, the affairs of law, cause of days, on 9th, he came in search of him in his workplace. He himself went to the police station on 10th to make a query to verify the police came search of him. And that's time I just arrested my lord.
You arrested. Oh,
4% I just driver my lord.
on the face of it, allegations are serious. Really? Hmm. And you say he's a neighbor of the. Okay, anyway, let us see what is. 10-4. The approaching statutory period also actually. 90 days.
70 days.
No, that's not a thing, but. TPS. You go through it, then I'll.
Yes, well, I have gone through it.
Oh.
The city. The city, well, your lordship may first, well, from the allegations in the FIR, your lordship may kind of, if one is, well, section 72 gang rape. And well, other is 123, well, causing hard findings of poison regarding those allegations are there. Initially, one boy, one companion, her statement is there, my lord, on that particular day. Because the accused person is known to the victim, my lord. On that day, my lord, he at about when the incident occurred on 8/4/26, at about 9 p.m. my lord. On that day, he come and my lord asked her to come out, my lord, at about 10 p.m. my lord. He along with one of his companion, my lord, on that night, my lord. Thereafter, my lord, your lordship may kindly peruse the statement of the victim and one from the medical report regarding other allegation regarding physical injury. He also bite on her, my lord. I could not save myself from both of them. Ultimately, Samord as the present accused, my lord, and his companion assaulted me sexually and injured my face by biting, my lord.
The other name of the companion is immersed?
No, my lord.
No.
No, my lord. And
During
regarding-
investigation also, it has not emerged.
Regarding to medical report, I would like to point out, my lord, regarding injury on his face, my lord. This medical examination was conducted on 8/4/26, 10:11 p.m. Immediately. Yes, my lord. Abrasion of size 3 into 1 cm, left side of face. 5 cm from, so my lord, face, my lord, and 4.1 cm below left eye, my lord. Multiple linear abrasion of size varying from length 3 cm to 1 cm forehead, my lord. And abrasion of 2 into 1 cm over the upper lips. So there are 3 injuries, my lord. And regarding the, that is the report of the GMCS and one of the report of the doctor, my lord. May I read, my lord? The patient have been explained about present medical condition of the patient and she was explained that, my lord, she need to be admitted in the hospital. In spite of her medical condition, but she refuses to, my lord, patient party refuses for hospital admission and want to take discharge. So, my lord, at that point of time, although doctors advised him to take admission, considering her, my lord, medical condition, but she refused. And thereafter, my lord, against their medical advice, she was, my lord, discharged from the GMCS. This is the hard statement.
But as far by my another for submission, madam, before, this may be a case of assault, madam, but not, but as far as section 70 is not affected here, madam. Whether case section 70, of course, one section here, that is the question, and section 123. Sir, that ingredients are defined in the city.
From her statement, your lordship,
I think-
she explained in detail, madam, 183 statement.
Assault may be there, madam, because of the media. So whether that actions are affected, what can you use that?
Final medical report.
Yes. It's there.
Regarding the other accused person, my lord, I have not.
Mhm.
Who is the other, my lord, companion regarding him, my lord, I have not found.
It is under investigation. Heard. So, the petitioner seeking regular bail under 483 BNSS in connection with Nunmati 55 of 2026 under so and so section. He was arrested on 10/4/2026. On which date the FIR was lodged by the alleged victim girl as informant. The allegation is that on 8/4/2026 after 10 p.m. She was called out of her house by the petitioner and then given some liquid substance to drink, whereafter the petitioner and the other person forcefully took her to the jungle and committed sexual assault upon her and also injured her face. In the morning, she woke up in the morning and found herself to be without clothes. Full stop. The learned counsel for the petitioner submits that the accused person, petitioner, and the informant and her family are known to each other, and that the allegation about rape is completely false and concocted. Full stop. Learned counsel submits that the petitioner has already spent 78 days in custody. The case diary has been received. The learned additional, along with a bail objection. The Mr. Borthakur, learned additional PP, submits that the medical report indicates abrasions and injuries on the face of the petitioner, face of the victim, thereby lending support to her allegations in the FIR about being injured, assaulted and injured on the face. Full stop. However, the learned additional PP fairly submits that it is revealed from the medical documents that though the victim was counseled for medical admission, but she refused and was allowed to go at her own risk. Full stop. The statement of the victim girl was recorded during investigation. Says in the said statement, she indicates her age as 22 years and has elaborately stated about the alleged incident. Full stop. She stated about being administered a drink, forcefully taken to the jungle, sexually assaulted by the petitioner as well as the other person. And she has also stated about being injured on the face and finding herself without clothes on the next morning, as stated in the FIR. Full stop. The identity of the other person allegedly involved in the incident is under investigation. Full stop. The IO has strongly objected to grant of bail at this stage. Considering the nature of the allegations, the materials revealed, and ongoing investigation, the bail petition stands rejected at this stage. Return the case to.
Hearing 35.
My lord, in this case, my lord, earlier he submitted that, that he has taken step through our office, my lord, as
Yes.
per the in person. But my lord, I have checked from my office, my lord, from record, everything in court order also I have gone through, but they have not taken steps as required under the procedure, my lord. They only they have taken steps by through speed post.
Even it was a learning from me also. I have overlooked, I didn't know this. It has to be taken through Office of Public Prosecutor.
Yes, yes, ma'am. They will have to first submit before the registry, then the registry will send it
No.
to the office of the.
Vipak, now I have to read that again.
Yes.
Anyway, just suppose you take by speed post and they come and suppose receive and come, then that might help. That might do.
Yes, ma'am.
But since they have not come, please take. No, just consume some time of yours. So that's all. It is submitted by the learned additional PP that those steps have been taken, but not in terms of it's taken by speed post, but not in terms of the prescribed procedure. And that service is also not complete upon the response. The petitioners will take fresh steps upon the response number 2 to the office of by the prescribed procedure dash Office of Public Prosecutor. Scan it is case diary.
Case diary receipt, ma'am.
Okay. So what will you do?
Then I will have to return back. I will again get it.
Okay. Case diary was received. Learned additional PP submits that the same will be returned and procured again with the up-to-date investigation.
Yes.
Okay. Immediately after reopening. List on
17,
16,
16,
16. Okay.
36.
Yes.
Petition, in this case, case diary not received, my lord, petitioner is in intent.
On entry. So let us fix it after vacation.
Nothing prohibited already all released. If we are process. And all 3 months,
Since we don't know anything anyway.
I think they are not just delegation said. If the execution of other poet, husband is ready to.
Anyway, Mr. Alamgir, Mr. Land Counsel. The case diary as called for is not received first. Issue reminder. The interim bail granted by the order dated 6/4/26 stands extended till the next date of list. List on 21.
21.
Will dispose it of. Good.
40.
40, my lord, as per my instructions, are sheet submitted.
Oh, this is BA. Just come.
NDPS, my lord, 21.
intermediate.
Okay, 483 bail application, seeking regular bail for accused so and so. In custody since 8/5/2026 in connection with Gorsuk PS case number 99 of 26 under so and so section. The allegation is about recovery of intermediate quantity of narcotic drugs in the by way of heroin, suspected heroin from the two-wheeler used by the petitioner during checking the stuff. What do you say? Investigations complete?
It is complicated. Let him, my lord, all appear before and my lord, file appropriate bail application before the trial court, because all the records are before the trial court. The trial court will consider.
Will you do that? Because we don't have the materials actually,
Yes,
that is true.
yes.
Only on the ground of completion of investigation, we don't know
After
actually what is.
submission of the search sheet, my lord, without perusing the, my lord, TCR, my lord.
But 2 week trial court is, district court is open.
Yes.
All throughout. That's true, but only on the, if he has to be given, he has to be given only on the ground of completion of investigation, only, because we don't have materials.
Yes, sir. Because after filing of search sheet, my lord, he has no, without perusing the TCR.
Okay. Okay, I'm disposing of it. Those two. The petitioner, the learned additional PP submits that in the meantime, completion, investigation has already been completed, and the same has resulted in a charge sheet. Learned counsel for the petitioner submits that he is ready to face the trial and abide by any conditions imposed. In view of completion of investigation and length of detention since 8/5/2026, the petitioner is hereby allowed to go on bail of 50,000 with one surety of the like amount to the satisfaction of the concerned learned court. Special Judge, Kamrup Metro, and subject to the following conditions, he shall be available for trial upon commences, shall not hamper or tamper, shall not indulge in any activities violative of the NDPS Act. Violation will entail bail cancellation.
Supplementary 61.
The covered case, my lord.
61 case diary not received, my lord.
Covered case.
My lord, we kindly see the order passed, because here Portsmouth will not come against, as per the FIR is concerned, my lord. The FIR is against the husband of the informant. And the lady, she is saying, she is lodging this FIR after 5 years of her marriage. She is saying that
No, let us see the FIR.
FIR is page number 17. My lord, look at the language of the FIR.
Very long.
It is the longish FIR drafted by some advocate, my lord, because the nature of the FIR, it starts, every paragraph starts with that, I was married, that after the marriage, and the subject is FIR for child marriage, domestic violence, and POCSO.
Earlier TCR was called for, my lord, TCR not yet.
Now, my lord, why I am saying this is a covered judgment, this is a charge sheeted matter, my lord. Now, my lord, I have been shown as an absconder in the charge sheet, not me, my lord. And me, along with me, 4 other persons were shown as an absconder in the charge sheet. And this honorable court, my lord, will kindly see page number 41. Because I am not the husband. The allegation is against the husband. Page 41, 42 is the operating one. Other 3, in fact, 5 persons, 4 other persons, including me, my lord.
Just a minute.
Earlier also considering his submission, TCR was called for, my lord.
Just a minute. Huh? This. Domestic violence, POCSO and child marriage allegations are there.
Against the husband. The other 5 people are not the husband. 4 of them, this order, page 42 is the order for 4 other similarly situated persons. Page 42.
Page 42.
42, and this order has not been challenged by the prosecution itself. Except para number 4. Here is the name of 4 persons, and in the instant application, there will be name of only 1 person. Otherwise, everything identical. Because he is not the husband, they are not the husband.
Who are they?
They claims to be the friend of the husband because
Friend of the husband.
she has a child and she wanted them to help her in obtaining the child. And since they did not help them, therefore he has implicated them, saying long back somewhere they had some relation with her 15 years or 16 years back, this sort of.
Anyway, so scanned copy is not available. You can make your submissions. Mr. Das.
One small issue, my lord. In this matter, my
Yes.
lord, from the first day, motion, my lord, I actually, my lord, was there as a counsel for the petition, my lord, but subsequently, when I was appointed as an amicus, my lord. So my humble submission is that another amicus is there, my lord. He may be appointed in my place.
Okay.
What had happened, when this matter came up for motion, I
Oh,
was out of state.
oh,
and
no
I
problem.
requested my friend to appear.
Heard learned counsel and this was of not really covered is on principle actually. Facts also similar things it can be covered, but similar, but
Not even an E, my lord.
I won't really say covered. Similar. M. Biswas, learned counsel for the petitioner, and the case diary, the scan record TCR as called for has not yet been received. Mr. Biswas, learned counsel for the petitioner, submits that the present petitioner seeking anticipatory bail in this case is not the husband and stated to be some acquaintance of the husband, acquaintance/friend of the husband. He has also relied upon an order dated 2/2/2026 passed by this court in AB 86 of 2026, containing that in similar circumstances, bail was granted. What happened to the husband? He is on bail? No, you do not. Mr. S. Das, learned amicus, submits that he had appeared in this case on behalf of the petition on the first day, and therefore he would like to be discharged as amicus. Learned counsel, the prayer is allowed. S. Das, learned counsel, is discharged as amicus, and in his place, I'll appoint you. Good name, please.
G.R. Datta.
Huh?
G.R. Datta.
G.R. Datta, learned counsel. Come forward, all of you should get chance. G.R. Datta is learned counsel, is appointed as amicus. You take the copy from him, okay? Press copy. So what to do, Mr. Sotago?
Earlier, because TCR was called for, TCR was called for.
What is the stage of the case otherwise? Appearance.
Appearance, so they have been shown as an absconder. Even it is against the interest of the prosecution also.
The case is stated to be at the stage of appearance. Issue fresh reminder for the TCR. However, in the interim, it is directed that in the event of arrest of the petitioners in connection with this case, they were allowed to go on bail of rupees 50,000 with one security of the like amount to the satisfaction of the arresting authority, subject to the conditions that he shall appear before the learned court bill on the next and subsequent dates, shall be available to trial if one commences, and not hamper or temper. The petitioner may submit fresh bail bonds before the learned court bill, whereupon necessary orders be passed. Okay. You'll have a look. Dispose it. The holiday also. Okay. Scan. In the context of the submission of the learned counsel and the materials available, I propose to dispose of the matter at this stage instead of keeping it pending.
Well, the difficulty is that already your lordship has appointed one amicus.
Yes.
And let me
No, you give an opportunity to your young friend, you know.
Sorry,
Yeah, please make your submission. Feel comfortable. You make your submissions. You've heard.
I'm surprised just now.
Yes, certainly. You're not prepared. How can you be prepared just now?
So,
So let it be, remain.
yes.
No? How? You see the file, everything is a learning experience. You make your submission. Okay, thank you. Take the date. You have not taken the date, Mr. Visas. Last week of July. When is the date there?
16/7.
No, later than that. Give it later than that.
28/7.
28/7.
Here in this case, before my learned friend start, my lord, I appeared, filed Okalatnama for respondent number 2, my lord. That is opposite party number 2. In the meantime, my learned friend is appointed as amicus curiae, my lord.
Okay.
So, my lord, today the respondent, the opposite party number 2 has come and executed Okalatnama in my favor.
Okay, no problem.
So, my lord, I will file objection, my lord.
Yes, every counsel, litigant has a right to engage any counsel. So if he is not there, then we'll apply. So you'll file a objection.
I already filed, my lord, Okalatnama,
Okay.
and I'll file objection.
You'll file an objection also. Interim is there. There's no interim.
Then meeting of the FIR, the agreement to event them for that restrictions are not accepted. That is my question.
That is
Space 12 months. Only one line.
unable. That's
Only
unable.
one line. Space 12 minor.
Yes.
For example, that's the only hanging my head. The only 5-year-old man is out of there.
Page 10.
Space 12. The Lord, yeah, state way goes behind it.
FIR on anyway. Say anything. Well, do you have any instructions regarding the case? Apart from,
But of course,
the power.
Instruction is this, my lord. He is running accused running a tuition classes.
Hmm.
And the victim guard is not his student.
Hmm.
But he insisting that you come in my tuition and I will give you question, etc., answer, etc. He's insisting on that. And another thing is this, my lord, my learned friend in the petition held that there is a family dispute.
Hmm.
But it is nothing said what is the family dispute. Only one line has been written that he is implicated only on the ground of family dispute. What is the family dispute? It is land dispute or some litigation or what? Nothing has been said. And another thing is this, my lord, your lordship would be pleased to see page 13. Page 30. His bail petition, anticipated bail petition was rejected by the court below.
Yeah, that's okay.
My lord, my lord, my humble submission before your lordship, let me file objection, my lord, your lordship.
Diary has come. Then you'll have to return it back to. So in this case, yes, hugging a person, don't be but as you know too well, the experienced counsel, is that word used in POCSO, intent, sexual intent.
Intent is there. So my lord, what is the intent? That will be from the evidence of.
That is not
circumstances.
circumstances.
Statement of the guard, my lord.
And however small, actually this is more in the domain of psychology perhaps. The girl, even if a small girl, she is actually the best judge
Yes.
of a situation.
My lord.
Young children are taught in that what is a good touch, what is a bad touch, these things. Actually. If she's feel bad, then it's
I humble
not
submission before your lordship, considering the facts and circumstances of the
well,
case.
very difficult.
What is the business of impressing her? When she is not, she is getting disturbed.
So anyway, today you have to, I think can be done. Let us see the statement. If it's in your favor, then maybe. The FIR has been lodged by father or the girl?
Father.
Okay, because in 164, there are allegations much beyond the FIR, actually.
Yes, so my lord, that's the thing that the law, in the, my lord, then my lord, then not possible.
They are much beyond the FIR, actually. Anyway,
So I might have the color.
no, FIR also, in the face of it, anyway,
Then I think that, my lord, move the police to the.
that's true.
That's fine.
Mm.
But my lord, I have seen my lord, and then he has to be my lord, his bedroom. my lord.
Baba Mari Dhore, and again, he said like that, she has said like that. So maybe these are very risky things, this kind of interpretation, very risky. You can go wrong. Anyway, so you file the objection. Huh? 14. Anyway, senior counsel and TJ Mahant. The petitioner is Mr. P. Thakur, learned additional PP. And it is M. Sikh, learned counsel for the learned counsel submits that he has been instructed and given the power to enter on appearance on behalf of the respondent number 2. Full stop. For whom Mr. S. Das was appointed as amicus. Full stop. So I'll discharge you. The learned amicus is accordingly discharged. Full stop. Mr. Sikh submits that, M.A. Sikh submits that that respondent number 2 seeks to file an objection and seeks some time for the same. However, the case diary has been received. Peruse the statement of the girl available in the case diary. Full stop. Then you file when should we fix it? When? After the vacation?
Yes, after vacation, my lord, definitely.
We have some dates, but
Immediately after vacation.
It's difficult to know because
Not my humble submission before your lordship.
I can, will you be available in between? It can be given
In between.
in between.
In
We have 4 dates.
Right.
Yes, I'm just asking.
In between is difficult.
13.
my lord.
Huh? 13.
On 13.
On 13.
Immediately after
As early as possible after reopening. Because of the allegation in the statement, it's difficult to give interim. That's why I asked whether it's lodged by her or father.
I don't know. Oblige.
13. Robo, yes, I know, huh? Yes. Robo. Yes, Robo, it's between the Robo. Population, my main list of the orders that are. A. এখানে না একটু সাপ্লি অ্যাডমিশন কি কি আছে 55 pieces এটা না এটা না আর টাইমিং ফ্লেক্স টাইমিং এটা আছে টাইমিং এটা এটা আছে আনলিস্টেড মোশন নেই এটা করলাম clear না what কি হবে
Unlisted matter. Item number 1, motion AB.
yes sir. No.
Last 50 lines of the And even if it's number after having the place of open, and also thereafter it could the bank. After filing the Canada has also kind of and in this figure, the first people in the house of the and petitioners for one person. Previous we have managed the medical science and in this figure, my daughter-in-law also lost a method and person to the hour third loss, 3 persons were there. And this 19 is my medical certificate of the number 1 loss. So, and this is loss.
The only problem is that it's a POCSO case.
That is
Well,
and so
get that clarification from the division bench as early as possible, really. Because certain situations it may be necessary. So feeling handicapped.
it's not that. Then other and trying to show the care.
That,
Other and paternal and interest is there. Delegating. Let's go to prime issue. This way. Last thing.
yes, I've seen. Assaulted me. What do you say?
My lord, here, first of all, Lordship is rightly pointed out, my lord. Here is a POCSO 8 is there, my lord. Even though allegation is not against.
Allegation against 2 and 3 is not
My lord,
POCSO,
not
however.
regular, but case is registered under POCSO 8. My lord. You will have to clear
How do you
that-
interpret that?
my
That
lord,
is the
on that
question.
point. And regarding my lord, present to petitioners, my lord, Lordship may kindly press page 17, my lord. That is 18, order at 18/6/2006, 26, my lord.
Hmm.
After going to the materials, my lord, case there, my lord, it was rejected, my lord. Their prayer was rejected, my lord. And 109 is there, my lord.
109.
No, attempt to. Against them, my lord. 1182/3/2019/10.
How did he sustain the injuries in this incident?
As a counterpart, they have closed. And person to the hour and 2 persons there from that side.
Sure.
However, the practice of our if the incident is also there. The Ganesh Star forwarding the post.
Your FIR is at page?
Not Ganesh Star, but it is reflected in the.
No, that is necessary.
My lord. In forwarding the post.
Otherwise, how will he
My
make out? Anyway, so let's,
At this stage, notice maybe.
it is
Notice and CD may be called.
page
Page 20.
23.
हमारा company is my doctor.
AP Sarkar, learned counsel for the petitioner, and P. Sharma, learned additional proofs. The petitioners, two petitioners herein are seeking anticipatory bail in connection with Nagarpara BS case number 26 of 2026, so and so. You just allegations. Just there's an order, page 17. Huh? This I marked. You can just take it from me. The allegation in the FIR dated 2/6/2026 is that so and so. The present petitioners are accused number 2 and 3 of the FIR. Learned counsel submits that drawing attention to the forwarding of Nagarbera PS case number 30 of 2026. We submitted that term. No, this is the later case. This is a later case.
My lord.
This is a much later case, actually. This is a much later case. This is on
14
30th.
Huh.
This is on
Letter
26.
14 it is 26, my lord.
No, this 26, Nagarbera 26, this is Nagarbera 30.
My lord.
This is not corrected, I think. 14/6.
My lord, letter, much
What is the
later.
Azahar of this? What is the date of the FIR? It was
My lord, page 15, my lord, that is the present.
It is not correct.
26, my lord.
Very different case. Anyway. So let us call for
My
the
lord.
diary only at this
My
case.
And notice will go.
Call for the case diary from the concerned police station. The petitioner, as the case has been registered under POCSO Act, also, the petitioner shall take steps for issuance of notice upon response number 2 by the prescribed procedure dash to the office of the, just write like that. Date.
My
Keep-
my lord.
it will be
The opening, my lord, 13th, my lord.
Because POCSO is,
My lord, notice will.
you have to take these things. You can just, the learned counsel prays for interim protection for the petitioners on the ground that the allegations made against them do not attract the provisions of the POCSO Act, full stop. I go back to the FIR and find that it is alleged that accused number 2 and 3, after arriving at the place of occurrence, assaulted the informant and her husband. Thus, prima facie, it may be correct to say that from the FIR, no allegations of sexual assault has been attributed to, no allegations of sexual assault or abuse of a minor has been attributed to accused number 2 and 3. In the said situation, it is directed that in the interim, in the event of arrest, 50,000 it funds the satisfaction, usual conditions, cooperate.
My
appear-
objection will be recorded
Yes,
here.
the learned additional PP submits that as the case has been registered under POCSO Act, the prayer for interim bail may not be considered.
Without crediting city.
They will appear, corporate investigation, appear for examination, shall not hamper or temporary dividend, shall not in any manner intimidate, harass or harm the informant and her family members. List the matter on towards the end of July,
My lord. 23rd, my lord.
23rd.
Rationalist to withdrawal.
The usual order, like MSF, Learned Council 6, prays to withdraw this bill petition. There is allowed, disposed of upon withdrawal.
Rationalist 3.
Or not.
Right, it is. Rationalist it is.
Page 33 of the IA. There are two, these are disposed of, right? IA 340. Sorry, this is the revision is 340. Oh, I am taking up the IA only. Hmm. Revision is already admitted over. That's first time. Page. Hmm.
The petition was arrested, Lordship, and it's been more than 1 month lost for petitioner to Hyderabad. The matter was compromised with the file. So what process is not hiding about that practice of the.
Where have you stated that it's compromised? Para? I'll see it. Because it's better to be on the pleading, right? Okay. I got it. Okay, in the meantime, if you prepare a document regarding the settlement and submit it till on the next day. You are also appearing?
I'm appearing for the respondent. my lord.
Also, you are already
We have
appearing.
received the payment on 5/5/26, my lord. Now we are not objecting on enlargement of bail. The
That's okay.
petitioner.
But the whole matter can be settled. You next date you submit a.
My lord may grant bail.
Oh, that's okay. That's okay. That can be that I am
Yes.
considering. But the revision also can be closed later on.
Later
You
on,
take a
later
date.
on.
You take a date.
Yes.
Should not be hurry. You submit a document that you have settled. Right.
Okay, my lord.
Submit it here. You can bring it through an affidavit.
That
It's
may be.
better you bring it through an affidavit.
Yes.
Then it will be compounded here. But you have to follow that Damodar Prabhu principle that if it's compounded in district, this much percentage, this much high court to the DLSC. Okay, that can impose a little bit of amount, but that's the law. Okay, you are Miss Mishra, learned counsel for the petitioner, revision petitioner. First, I'll have to pass in the order of revision. What's the revision petitioner, Mr. Joynath Das, has preferred, has invoked the revisional jurisdiction of this court under 442, 438 VNSS, agreed by judgment and order dated 1/10/2022, passed by Learned Session Judge Dibrugarh in Criminal Appeal 28 of 2018, whereby the judgment and sentence dated 27/4/2018, passed by Learned CJM Dibrugarh in CRNI case number 79 C. C is actually superscript of 2014, was upheld and confirmed. By the said judgment, the Learned Trial Court had convicted the petitioner under section 138 of the NI Act 1881 and sentenced him to undergo SI for 3 months and fine of 4 lakhs, in default SI for 1 month. Stop. Learned counsel in the next paragraph, Learned counsel submits that in the meantime, the parties had entered into an agreement whereby the financial liability was discharged. However, due to the judgment, due to the judgment and sentence, he was arrested on warrant. Warrant was issued, I believe. He was arrested on warrant and presently in custody, serving out the sentence. Full stop. Learned counsel, your good name, please.
S. Upadhyay, my lord.
S. Upadhyay enters appearance on behalf of the sole respondent complainant and submits that complainant has no objection to grant of bail and that the parties have arrived at a settlement. Full stop. The parties are at liberty to submit necessary document before this court, preferably through an affidavit in support of the contention about settlement of the matter, so that necessary orders regarding compounding can be passed. Full stop. However, do we need to get the case record? It's not necessary, I think. It's not necessary. Full stop. Extra copy may be furnished to the respondent if necessary. Stop. List the matter. After the break, on, you can choose a date. 31st of July. 31/7/2026 in the notice may be issued. No? Issue notice upon the respondent, just write line in the orders column. In the orders column. Then you write IA so and so. Upper part to ekya upper part. Revisional jurisdiction so and so. You write that first. By way of this, write everything, all this settlement and everything. By way of this interlocutory application, the revision petitioner invoking the powers under 430 BNSS is seeking suspension of sentence and bail. Right, all the things will be there already, no objection and all that. Full stop. In view of the aforesaid developments, full stop. Till the disposal of the criminal revision, the execution of the sentence dated so and so. Both the sentences, huh? That's and so. This is merged actually. Shall remain suspended, and the petitioner is hereby allowed to go on bail of rupees 20,000 with 1 surety of the like amount to the satisfaction of the concerned learned court, and subject to the condition that he shall cooperate with the process of law. That's it. The highest expense disposed of. 20,000 I've given. Is it okay? 20,000. 20,000.
Deeply over there.
Time being due. I mean,
Time being at number 22.
chamber division কেটা হয়েছে এখানে? 2510.
For the lordship, in fact, the violation of section 28.
48.
Yes. Okay. Never issued any under section 48 of the latest plan. And she is no more representing the violation, the proceeding is to comply with the medical section 48, the BNSS pilot, but it is entitled to release the paper. Based on the non-compliance of section 48, my lord, my case for the lordship, shall consider the section of their pilot.
That is one ground.
Yes.
Only ground.
Yes. This can handle the ground pilot.
According to you, there is no compliance at all.
Yes, at all. In fact, pilot, there is no notice available on the record.
Okay, fine.
Yes. Yes, yeah, but-
Okay.
see, look.
You can supplement, but you have done a good job. Huh.
Yes. Now already, 1 year, 6 months are lapsed. Now the you only want to tell 13 disseminates. Now your question your lordship is ready to see. So only issue here was with regard to the notice. And
Trial has not started also. Trial is going on. Going on. 13 witnesses. Huh?
1.5 years already. Now your lordship, kindly was page 143 of the second. Until 23 and we take up 23 for the.
Item
So here point out.
23. 23 to the.
23 from the same.
Yes, yes, 23. Main file to the. All of them. Yes.
One point. Page 143 is the notice on the section 40. There is no dispute, the notice that has been given. 143.
Yes, 143, 47 notice.
It's a very tricky type of a notice, not specifying whether where it is. The cases, grounds of errors, nothing like that. It's a small paragraph has been given. So they have indicated with regard to the 26 kg of so which is punishment is not as so this has been given, but specifically about the grounds that should be given as part of the earlier judgment. What we want, I can repeat. They have stated that it should be very specific regarding grounds of marriage. Now we also turn to the next page. Now my learned friend has already stated that 48 section has not been complied with at all. No notice under section 48 has been given. So in that regard, I would like to point out one thing that you will also find in page 144. Now you will also see 144 is the arrest memo. Initially, I thought that there was no signature of witness. No witness has been stated here as signed. But my learned friend pointed out to me that the signature of the punch witness somewhere in the site. So I will not make that a submission now. But this first paragraph, what you will see at the last two lines, this is with regard to 48. He has been duly applied last two lines of first paragraph.
Over.
What we have seen that he has been duly apprised the grounds of his arrest, and his arrest has been intimated to his brother over phone. Now, your lordship, what is this? Over phone, which phone number? Nothing. Who is his brother?
What's okay?
Not a whisper here. And in fact, our specific ground is that your lordship will obviously be stand up is there. Lordship will see that not a notice has not been sent at all on the section. So there is a specific violation on the section 48 of the. In this case, your lordship, we have also annexed the judgment of this coordinate bench of this also. What is the long-time judgment? Here, section 48 has been considered. Bail was granted. It was by Honorable Justice. But subsequently there are many other judgments where this very specifically stated that there are two judgments, three judgments on coordinate bench.
Not necessary, because of two factual determination we have to make.
Very can construed from the arrest memo itself that actually it has not been, but in fact it was not even.
It was in December 2024.
Yes, this was 26th of December.
At the time they didn't. At the time they did not know also. At the time it was these things have not come.
Yes, we have Lord that has been force as of today.
Today I would blame the IO, but at that time not so much. Right?
Maybe, but
They did not know. But the person will get the benefit
But question, one thing for your lordship.
because it is not been it has not been held to be prospective. That is
one thing I would like to point out that these are violation of not only the Act 4748, these are also violation of Article 21 and 22 of the Constitution. Lordship knows the Constitution is from 1950. There was one case.
interpretation is like that now.
That judgment. Again, I can.
Anyway,
Hari,
we'll not spend time on that.
There it was there. So we cannot say that it was not there. Now, after Bihan Kumar, it has.
This interpretation was not there. This interpretation was not there.
Bihan Kumar elaborated this.
Anyway, Hare Krishna. You can give me, I'll have a look. Hare Krishna, if you have. You want to give me? No, it's okay, no problem.
That was not bad.
Okay.
I think.
That's why I want to see what was said at that time. I'll Hare Krishna, no, I'll take it out. I'll take it out if I get time later. Hare Krishna, no? Oh, then I'll find it, no problem. Return from Prohibitions, find a citation, no problem. We'll take it out. Yes, Mr. Kyle, please.
Lordship, there are two grounds is made before Lordship. One is delay, second is notice under section
Number 48.
Lordship, no,
Delay.
your friend has been already mentioned.
Delay is not, no, you are not mentioned. Mr. Chaudhary said that only 148.
Yes. Lordship, with regard to,
Uh.
Lordship may come to page 161 in item number 23, paragraph 9.
Yes, I'm on 23 only, page.
Page 161, affidavit filed by the department. Paragraph 9,
163.
150, 161.
161. Affidavit, yes.
May I read
Page.
lots of entire paragraph? Because we have denied their contention and in middle part. That with regard to the statement, amendments made in paragraph 6 and 7 of the present bill application. The amendments raised herein in the above paragraph.
47, it has some narration.
No,
It
Lordship,
has some narration.
Lordship,
47 notice has some narration.
we
It has some,
explain-
it has some narration.
so below this
But 48
paragraph-
notice, probably the telephonic thing is there only.
Yes, it is there. Then Lordship may come to page 185.
You mentioned about substantial completion. Anyway,
Lordship, London trial court while undertaking the bail application of the present petitioner. Lordship, page 185,
just a minute.
last paragraph. Now, coming to the compliance of section 48 BNSS.
Page
Page 185.
185.
This is a part of the order of the London trial court, sorry. Considering the bail application of the petition. Last paragraph of page 185. Now, coming to the compliance of section 48 of BNSS, admittedly, the instant case, the ground of arrest in writing were never furnished to the family relative of the above named accused. However, there is no dispute to the fact that the brother of the accused was informed over telephone about ground of arrest. Not a single averment is made in the bail application and no submission was made during argument as to how come the petitioner came to know about the arrest of the accused named above named accused. Also, there is no averment in the petition. Friend relative of the accused was not aware about the ground of arrest of the accused, or that the friend relative were never informed about the ground of arrest of the accused. Thus, it is crystal clear that the ground of arrest of the accused persons were intimated to the by the DRI to the brother of the accused. The provision of section 48 BNSS and also the aforesaid judgment of the Bihan Kumar and other judgment orders relied upon by the learned counsel for the petitioner are not passed and with a view to grant bail to the accused purely on technical ground. That is in absence of non-intimation, the ground of arrest in writing bail has to be granted, irrespective of the fact that the friends relative of the case were duly informed about the ground of arrest. Considering the facts of the case, I am of the view that there is a substantial compliance of section 48 of BNSS and bail application was rejected. In Lordship, I want to rely on two recent judgments in the Supreme Court. One in state of Punjab versus Gurujit Singh, page paragraph 10, 12 and 13. Sure.
Gurjit Singh. Gurjit Singh.
Yes, Lord. Given the copy, Lordship, I have marked the paragraphs also. Now, Lordship, as Supreme Court says that in case of special act where NDPS commercial quantity is involved, compliance of section 37 is necessary. And article 21 cannot be placed into, although it's an important part of legislation, but in case of special act, lordship, that can be waived.
Which is the para, 10.
Lordship is taking which judgment, lordship? This thing, lordship, 10, 12 and 13.
In this case, there was a violation of 48? No.
Which case, lordship?
Generally, though, definitely those principles will come.
Lordship, there are two judgments.
They are very strict also. This
Yes, sir.
for reasons, there are reasons why they have been made strict.
Lordship.
There is a reason why 37 is there.
Yes.
Commercial quantity means trafficking,
For the first time.
not for sole consumption.
For the first time, Supreme Court says that Article 21 is cannot be placed in case of a special act where commercial quantities. And in the case of Lordship Balraj Singh, Supreme Court has taken note of the earlier judgment passed by Supreme Court, where period to granted, where delay was there, and on that ground, Lordship many people has been granted waiver. But Supreme Court says that it cannot be placed into place, Article 21 each and every case. And in case of a special act where commercial quantity is involved, the mandatory observation of section 37 is mandatory.
I will see.
Not. But see, 28 is also same.
Mhm.
Grounds of. Yes, but no, you can. My argument is same in the 28.
Your argument, you reserve the argument.
Yes.
Yeah. Just out of interest, I want to say, since what was the language at that time? So.
That. 1960. Why I'm referring, because your lordship said that at that point of time, in 2024, this, but.
No, I'm not saying that, I did not say that, I cannot say, of course, that in 2024 these principles were not applicable. But we did not know that these technical flaws will make the arrest untenable and give a right to bail, prevailing over statutory restrictions also. That we did not.
Knowledge of I request for the state of Maharashtra.
And
1960. That's 60 online. I'm just giving the citation for your lordship.
Okay, thank you. So,
That's C online. SC 117. SC 117. You know the paragraph is there.
these things are not rocket science, but only thing is that in the interest of everyone, whatever is laid down should be laid, the law should be clear.
Yes, that is.
No ifs and buts.
Yes.
Clear, so that you know what is to be followed.
And your lordship wants support with that.
No, not necessary. So anyway, so this is, okay, we're done with this. Then you, what is the number you said? 43?
28.
28. Your submission is the same. Mr. Okay, Mr. Mehdi is there, no? You're there.
22 is there.
Yeah, the 22, you have made your submissions. 48.
Your lordship, sir.
Don't give my judgment. If you give me more judgment, I'll have to go home tomorrow morning. It seems quite a likely possibility. No. I'll finish everything.
Yes.
Like,
Mr. Mehdi, you complete.
Yes, Lordship, I'm not going to take much time. Already, like we are continuing with the particular petitions which are actually now we are like we have 5 years different bail applications.
non-compliance of 48, in it also same. Now I'm directly going to their objection. Directly I'm going to the objection, kindly come to page number 182. Because this is important just to draw the court's attention, how they actually prepare their, what is the way they are making the affidavits and how they are actually carrying out those particular administrative things. This is 182.
Just one. এইটো সেইটো ৰ'ব দে এইটো মিক্স আপ হৈ যাব এইখন এইটো তাত দি দিয়ক এইটো মই বেলেগকে লওঁ নালাগে এইটো বেলেগকে থওঁ জাষ্ট এ মিনিট নাম্বাৰ ইট ফাৰ্ষ্ট Okay.
Here objection. Here objection. It is further, the first paragraph starts. It is further evident from the record that the accused was informed of his right to have a relative friend informed of his arrest, and accordingly, intimation of arrest was duly communicated to wife over. These facts have been mentioned in the arrest memo and acknowledged by the arrest by affecting his harm impression, attested by two witnesses, which satisfies the requirement of section 48 of the BNSS very well. Now we go to their arrest memo, which is page number 207, annex A of their objection. One 207, annex A.
Yes.
I'm directly going to the relevant line.
Yes, I've seen this.
He has been duly apprised
Yes.
of the grounds of his arrest and has been intimidated with father over. So there is wife, here there is father.
No.
So this sort of infirmities, this sort of discrepancies directly shows that at that point of time itself, the law was clear at that point itself. Because Pankaj Bansal was passed on 3/10/2023. Profil Putyasu was passed, it came into effect from 15/5/2024. And then came Mihir Rajasa in 6/11/2025.
Anyway.
In between there was
Okay.
Nihal Kumar.
Okay.
So now the law has been crystallized. It is nothing of that sort that there was no law at that point of time.
The law had not crystallized so much in 24 December,
Yes,
but
my-
now it has crystallized.
Yes, yes, my-
But
and
you,
the fact
no
is-
quarrel with that.
Yes.
You just make your grounds. That we'll see.
My main ground here is 48. And there are some other grounds are also there. And their main objection is they are harping on the fact that 37 is not satisfied. Because of the fact that there was commercial quantity, the person is like he's the mastermind. He was found in possession. Though actually it was found from the hood of the car and the seizure was when the seizure was done and later in their confessional statement, we cannot take it into the fact that it was a statement given before the police. And the trial has not started. It is for only appearance. Charge sheet was filed on 13/6/2025. 1 year, 10 days have already passed of passing of the charge sheet. Now he is behind bars since 554 days. Now my question is that if the particular plea of this 48 was not taken earlier, now we are taking because the rejection order by the lower court directly says that they have not mentioned anything regarding challenging the 48 notice. Yes, that is why we are challenging now. This is a fresh ground. This is not a ground which we have taken there earlier.
This is not a subsequent bail application.
No, yes, like in the trial court.
That's the leave. Forget that.
Yes, yes.
So anyway.
So basically, my contention is that their contention that substantial compliance has been taken. And my contention is that if it is a mandate, substantial mandate cannot be substantial. Mandate is mandate. It has to be fulfilled. 22(1) has got already has stated mandate.
Well, that's for the Honorable Apex Court to say whether substantial compliance will do in serious cases like this.
Absolutely. Now, the fact is, one of the co-accused has also been enlarged. We are not taking parity because his role may be different. And the co-accused role may be different. We are not taking parity, but we are informed that co-accused has been also enlarged on the same ground. And at the same time of the fact that
You have that order.
yes, yes. We have collected by your document, by this very good.
Okay.
That is page number 173. Annex R. That is the order.
Okay.
Lordship has in a very well mannered, in a detailed manner, have passed the order, citing all the cases at the same time, the requirement of the compliance of the statutory mandate, which is under Article 21. So, and regarding the judgments which they have placed in their objection, all of them are mainly concerning around the 37. That of the fact that discipline factor is not satisfied, and there is every possibility that this person, if he is allowed on bail, he will go and again he will start their illegal activities. Now the fact is that in the last the recent judgment where my learned senior counsel had stated before the Honorable Court Gurjit Singh, in that matter actually what has happened, he was running a racket from the jail. He was running a racket. He was having all the access. He was using phone. He was having a racket. So now this guy, he is just the person who was actually at that point of time, his brother and some other ladies actually involved. Now he has been dragged into the fact because his bank transaction is showing that he has purchased. But he actually doesn't know ATM card, everything was there with his brother, and police have not been able to get his brother because his brother is now, he is expired. And then therefore they are conducting investigation whether the brother is expired. And then there is one lady who is not being found at this point of time. Now he is having one small cloth, belt and cloth shop in that particular place of business. So concerning that, and so much of big amount is invested, he cannot be directly using his access over the bank account because he is not that literate also. So concerning all those facts, court will take it into account, and if court is satisfied, then if this is a fitness way, because of the fact that we are not taking into the prolonged incarceration also, because he is not 554 days old. Only fact is statutory non-compliance. At the same time, there is no chance that he will abscond if strictness of conditions is given, because he's not from outside the state, he's from within the state, he's from Sri district. So he can be any security can be taken in for him, and the conditions can be placed. Even passport can be, if at all. I do not know if he has a passport considering his like the status. But the fact remains is that whatever they have objected, they have mainly objected regarding that 37 is not satisfied. 37 and part 4, if it is there, then the statutory compliance may not be, it may be overdue, because of the fact that personal liberty comes second, sovereignty comes first. So in that particular way, if the heinous crimes are taken into consideration, and this has to be taken to the fact that whether this constitutional mandate in 22(1), I'm not into Article 21 also, that 22(1), if the arrest becomes illegal, then whether he can be set out of detention or not. Our main concern is that 37 comes subsequent to the arrest.
Okay, that's well settled.
Yes.
Okay.
My God, I will raise some
Okay.
words.
Approximately please to see the seizure memo. And I can say that it was not recovered from him. Page 28 metric, approximate.
No, it was recovered from, according, I've seen it.
Pages.
He was the driver of that vehicle.
No, he was not the driver. He was sitting driver of somebody else.
12 kgs of methamphetamine tablet.
Driver was the co-accused. He has been only.
Methamphetamine, these are very dangerous things.
Yes.
Finished. People are,
Lord,
if people consume these things, no, they'll be
That's why Lord says.
walking skeleton.
Yes, Lord, this is.
Anyway,
the big,
but we have to, the main thing is conviction rate, actually.
Lord,
Everything else becomes secondary.
problem, Lord, Lord,
Yes.
point is same, which has been made in item 50.20. Here, Lordship,
Page
page 38.
of your,
No, bail application.
of the bail application. Anyway, so
This seizure memo.
break room. Last one.
If
Break.
is the judgment placed by me, item 22, that will be covered this case also.
Page 38. I've seen it.
Oh.
Break, last minute.
The total seized item was 12 kgs of methamphetamine tablet. Value is about 12 crore.
Yeah, it is. It will be international market.
Lot.
Your lordship.
It is no, it will be governed by the prevailing law. That's all.
Not said.
Anyway, anything else?
What?
Just 5 minutes.
সবাই সব করে গেল, সব করে গেছে, দেখুন। কালকে আসলে 7টা সিএবি টেম্পারি সিএবি এই টেম্পারিক এখন পাই নাই। Time being 26.
It will last more time.
After. Twenty-six.
Yes, yes, I remember. Yes. Order is annexed. Can have a look. At page. Okay.
Therefore, there appears to be a violation of the mandate of in the address of the based on the above itself. Evidence that there is a privacy violation of both several facilities and complete. With regard to the of the address report does not give us an address. This is.
Yes. Yes.
My lord, here, my lord, I have gone through the record, my lord. I have checked mark, my lord, regarding 48, my lord. It was admitted fact that it was, my lord, WT message was sent to the concerned police station, my lord. And regarding 36, my lord, I have flag mark, my lord. Our main contention is that, my lord, in a Dorson, etc., it was clearly mentioned that, my lord, if only there is a procedural lapse, my lord, the arrest may not be associated, my lord. That is clearly mentioned, my lord, and we are also on the 37 rigors of 37, my lord. As my earlier, my lord, in the earlier case, my lord, senior already argued regarding the, my lord, state of Punjab versus Ballar Singh versus Billa, my lord, that judgment, and also, my lord,
Okay.
we are mainly concerned with the, my lord, section 37 of the, my lord. Here, rigors of 37 will have to consider, my lord. State of Punjab versus Gurjit Singh. There are two judgments already.
Subhash Sharma, you are relying on.
That the illegality of arrest. With that goes in favor of the bench. First, I got a sound something that this
Okay.
Yes, state of Punjab versus Gurjit Singh Gittu.
He has submitted.
Already submitted, my lord.
I'll go.
My lord.
Okay. That's all.
My objection is there, my lord, as is heinous offences are, my lord, and huge number of my lord contraband were recovered from their possession, my lord, conscious possession, my lord. It was from their vehicle and secret chamber of, they have prepared secret chamber, and from the secret chamber it was recovered, my lord, from their conscious possession, my lord. And my objection is there as it is the commercial quantity, and recovered from their conscious possession, my lord. A recourse of 37, my lord. And Dawson also said that, my lord, only on the procedural lapse, my lord. It cannot be preceded.
Next, another. Yes, I've seen.
27.
Oh,
Service report, my lord. They also, my lord, I tried to get the confirmation regarding
but not received.
service report, my lord.
Then we'll have to fix it in the, we can fix it in the. I asked in the registry, in between, that there is a, the guideline has been uploaded, no, but apart from that, a few cases you can fix, that's not a problem.
Yes.
So that's okay, but not too many, of course. So if you want, you can take, somebody will be there for the vacation bench, right?
Yes.
Take instructions. And case diary has been received.
Yes, there is.
Case diary is available, however, the instruction is still not available regarding the service of notice upon respond number 2. But during vacation bans, again, availability of amicus will also be an issue. Huh? Maybe we don't know, no? But it's after the service of notice. So if you are agreeable to after vacation, then it's okay. But otherwise, we'll have to choose one of those dates, 2nd, 7 or 9.
They have also not taken steps to our office, my lord, till now. Only speed post, my lord.
No.
Here also, my lord, this is the.
Becomes easier
Yes.
if it's through PK.
If through our office, then we can get the instruction from the police station, but if through post office, my lord, then how police can.
Should they take a fresh step?
Yes, let them
You
take. a-
you guide the court, whatever.
Yes, but let them take fresh step through.
Huh?
No, my lord, although they, my lord, without going through the records, my lord, they submitted that they have taken step through my lord, registry, my lord, but they have not taken a step through registry by speed post, my lord, but they directly taken the
It's
step.
pointed out, it is submitted by the. You have not, you have taken through speed post. Also, it's submitted by learned additional PP that steps have been, no, cut it. No, stop. So what do you suggest?
Let them take fresh steps, my lord, in
The
the meantime,
petitioner,
suppose.
The petitioners will take fresh steps by the prescribed procedure dash to the office of the to the assistant, no? Full stop. The case diary will retain.
Yes.
List on.
14/7.
Oh, then will you retain? Retain it. If it's not hampered unduly, then you will retain.
Your lordship may not record regarding it, and in that case also, I will try to get the case diary.
Okay.
returned.
I'll not say anything.
Yes.
14th. He said that keep it vague. You will send it back.
Yes, ma'am. I will get it on 14th, I will put it.
I go for one of it.
Regarding.
Item 42.
Maybe he's too excited for the holidays.
Yes.
Anyway, what is the matter otherwise? It's a civil revision.
Yes. The CEO will drop the last and I have taken steps also.
Just let me,
number 3 appeared and certain from response number 1 and 2 away.
as agreed by order dated so and so, blah, blah. Petition adjournment of three cases. What was the matter? DW evidence was
CW
closed. You wanted to adduce more evidence.
must take by.
Hmm. Notice was issued. Notice was issued. There's an office note.
3 has appeared. I have taken the dusty as well. On 3. 3 has
Appeared.
1 and 2 has appeared.
Insufficient address. 1 and 2 dusty not possible. Hmm?
And the claimant.
Oh, sorry, insurance. They've appeared. Then we'll have, it says insufficient address. Stop. Heard, Mr. Land Counsel for the petitioner. Full stop. The revision has been filed, agreed by order dated 21/2/2026, passed by the learned tribunal, closing the claimant with evidence. The petitioner claimant seeks to adduce more evidence. Full stop. It is submitted that upon steps by Dusty, respond number 3 / insurance company has entered appearance. Full stop. However, as per office note dated 24/6/26, service report is awaited with regard to respond number 1 and service failed with regard to respond number 2 due to insufficient address. Respond number 2 is the owner. Driver is not driver, it's okay, may not be so much necessary, but owner, but this is they just contested by the insurance company. Is he contesting? Owner. Owner is contesting? No. Okay. You have to check, no? So you have to take fresh steps then, because insufficient address. The petitioner shall ascertain the correct address of the respond number 2 and take fresh steps. There's no harm in Dusty, I think. Also, owner, the fresh steps by speed post. The petitioner is also at liberty to resort to Dusty service. Usual mode.
Usual mode as well as speed. Both are.
Steps to be taken by speed post and usual mode. It is in our own interest, to speed up. Interim order of stay dated 11/5/2026 stands extended till the next date of listing. Leaves the matter on after 30th July.
Okay.
Main list of order আছে কি? Main list of order আছে। Main list এ হয়। Complete order আছে নি? Mention করে।
এইটা আছে 64 টা আছে। 64 লাস্ট আছে।
Etu?
এটা হইছে।
এটা আছে নি? Okay. "70 days in preferring a revision against concurrent findings of guilt. Only state is the party. Only state is party. So I think we can dispose it off. no?
Yes.
90 days and then 70 days.
85.
The petitioner, the applicant petitioner is seeking to file a revision against the judgment and order dated 18/12/25 passed by the learned session judge Udalguri in criminal appeal 35 of 2025, upholding the judgment of conviction and sentence dated 7/7/25 passed by learned ACGM, additional CGM Udalguri in in PRC 379 of 24. Full stop. However, there is a delay of 70 days in preferring the same, for which an application under 5 of the Limitation Act, Section 5 of the Limitation Act has been filed, giving rise to the instant interlocutory proceedings. The sole respondent is the state/prosecution. Heard both sides. In the interest of justice, the delay of 70 days is condoned. The IA stands allowed and disposed of. The revision may be put up for admission hearing. Nothing needs to be passed now. Delay. The petitioner is seeking to file a revision against order dated 28/1/2026 passed by the learned special judge Golaghat, rejecting the petition of the applicant for interim custody, JIMA, interim custody within bracket JIMA. JIMA of what? Of a vehicle which was seized in connection with Dergaon PS case number 157 or 25. Full stop. The state is I don't know what. 48 days. It's condoned. Revision put up for admission. Okay. I disposed. 64.
Item 64.
But here, this was the POXO matter. Notice won't be necessary. Notice is served.
Answer.
Acha. You took through the office of the PP, right? But you have to complete the procedure, right? But without the notice, it will be incomplete, we cannot take up actually. So what is the way out? He has taken through office of PP. Can you take instructions or press service he has to take?
Press service, madam.
Huh? Press service.
Take now some time, one day more important,
No, but I have to complete the procedure.
Cannot be said that unnecessary, madam, but condition.
I also have my accountability.
After going to the evidence, madam, conviction was given, madam.
Where is our
Not done.
testimony? Let us- No, it's okay. No, we exist for you only. You lose free matter.
That's what. I was renting clothes of my room. Then they entered my room and raped me from backside. I will also manage the last sentence of the cross. At the time of occurrence, our main gate and the door of the house were closed from inside.
But that would be a matter of appreciation of evidence, that cannot say, see,
He entered my, they don't know the explain, man.
oh, but the thing, you cannot say it's a, see,
There is a my lord enmity between the family of the
no, if the examination and chief of the victim taken on its face value also does not make out any offense, then you can say it's a matter of.
From this
So, he entered the room, grabbed me from backside.
It does not explain, man. There are 15 say that the time of occurrence our main gate, the main door of our house will close from inside.
That is the only contradiction you're saying.
Yeah. This is the most basic thing. There are other
He
materials.
has repeated also. You see para 12, come to para 12. Para 12. He has repeated also.
Suggestion, my lord.
Touched my this thing and pinched on my face and so and so.
How he entered, my lord. They does not explain, my lord.
That I don't agree that it's a case of outright no evidence. It has to be appreciated. Whether the finding is correct or not has to be seen. Kindly take fresh steps. Let us complete the procedure. And then we'll certainly see it. We'll take it up. You can take it up for final hearing also.
My lord,
But it's the appeal is of 24. We can take it up also.
My lord, 4 years conviction, my lord, already filed.
We can take up the. Yes, we can take up the.
For final hearing also.
For
my
final hearing
lord.
also.
Notice and final hearing.
The record has come.
Not,
PCR has come.
not, my lord, not so.
Hasn't it?
Yeah.
Yes, they followed like.
Unbelievable.
Was not shown in the policy.
The
There is enmity between the.
I see. No, কিন্তু হেৰিবিলাক আছে নি documents আছে নি the time of occurrence of main gate and main door occurrence close to means. See, the thing is that in this kind of a situation where the main gate is said to be closed, main door, then the sketch map becomes relevant. When the sketch map have been executed, what is the structure? Sometimes you may have main door, main closed, then sometimes main door of the house.
Main gate.
Main gate and main door.
Gate. Gate.
Yeah. Main gate and main door.
Main gate is there.
The house, man.
Then
may also intervene.
it depends again, that
It is their duty also, they have put question in the cross manner, how did he enter manner. That's not
Prohibitions support the my lord.
the procedure has to be followed.
Right.
It is submitted by the learned additional PP that service upon response number 2 failed. Was failed, and therefore perhaps the appellant may take fresh steps. Fresh steps may be taken as per prescribed procedure to the office of the public prosecutor, so and so, so and so. It would happen. The criminal appeal. The appellant shall take fresh steps upon response number 2 through the office of the public prosecutor, as per public prosecutor, as per the prescribed procedure. The appeal was admitted on 21/11/2024. Full stop. Else, TCR was called for, it has not come. Full stop. TCR was called for, it has not come. Yeah. Scan price. Original to হলে ভালো হয় বেশি আসলে মানে the scan TCR is as called for is already available. Full stop. If you want, we can fix a date and hear it finally. You can hear it also. 24 matter. let both come together.
My lord.
Full stop. No, it will come in hearing column only because this has been admitted actually. No, we can take up for final disposal actually.
Let me answer.
We can take it for final disposal also. Hmm. Four eight. It's already underway. No? Yes. Can be. So, will 28 be okay? 28 is okay. We'll see. Open. IA is also open.
My lord, open.
And suppose again there's delay in the steps, then we'll try to hear it on. No, that's not.
2 days.
That's 2
1 day,
days.
2 day, my lord.
2 days. But notice on both, appeal also.
Right.
Notice has to be
Right.
seen. Because otherwise the appeal will not move. Yes, no.
My lord.
please. No, I have official person. Through the office of PP. Okay? It will save you time. And then
Fine.
Admission item 55, 56.
out of 9. No?
Nine.
Out of 9.
Last.
Yes, can you just refresh me? This, what was the matter? This one?
One is for, you have challenged the.
Oh, it's the extension. Extension. Yes, and bail. Extension and bail. That's it. Report of the public prosecutor. That
My lord, in this case,
it was not there.
yeah, application.
Okay. Anyway.
My lord, we have completed here in the jail, 446 days today. Without trial.
Investigation is completed.
My lord, it is a complaint case, but offensive was not filed till today. In spite of the fact that after the extension was made, after the extension of the IU prayed for 6 months, 90 days, but the Lawyer Court has extended 180 days. But after that also, there is a 262 days, 52 days today, minus 180 days, minus 252 days today, the offense report has not submitted. So, my lord, interesting matter here, the IO has applied. I was arrested on 7/4/25, and my lord, on 3/10/25, I have completed 180 days. But on 3/10/25, the IO has submitted the application to PP that he could not complete the investigation. He required some.
The application was submitted on 25.
That was on 180th day.
188th day.
180.
180 day.
On that day, it was accepted and matter was picked on 16/5/10/25. Order was passed for extension. Could you follow me?
Oh, no.
On
310 to
10/25
it was application was given
was filed. No, it was order was given by the court below.
or 310.
No, the 16/10.
6, sorry. The application was filed on, oh, that's okay. Application was filed on 3/10/2025, and that was the 180th day. 80 day, 80th, 180, and then the order was 16/10/25.
Now, I only query before the lordship. This different 11 days, 13 days, there was no order of extension.
Hmm.
How, then what was the fate of the client, the accused my lord, these 13 days?
Okay.
Now, my lord, I take your lordship, application was filed, here your lordship will find that till date no offense report was submitted, till date, after getting extension and beyond 250 days.
It was extended by 6.
Extended by 180 days.
Acha.
Again.
At a stretch.
But even then, after the expired 180 days also, second time, 250 days is over. No offense report was filed.
Oh. 100. This will be 360 days.
Again, 250 days has been consumed. No offense was filed till today. As such, my lord, practically there was.
It was extended by another 180 days.
80 days.
Straight away.
But
Then
after
180 days means 360 days. But out of 360 days, 250 days already over.
No, more 250 days has been.
Oh, acha, acha.
They have ex-
Nice.
But without
Now-
this action, there was the extension.
Now I get it.
Fine. Then, my lord, your lordship will find.
Then it has exceeded 430 days. It will be.
Yes. Total my lord, 446 days, my lord, behind you.
446 days.
46 days. Now your lordship will find the regarding this, my lord, this extension, my lord, it is mandatory that notice must be given to the accused man. That is Vidyagar, my lord, that is just our own high court judgment.
I think there's one Supreme Court judgment also. I think notice should be given. No, there's a Supreme Court judgment also, I think. Our High Court is also there.
Yes.
Supreme Court is also there.
But-
Notice has to be given
Yes.
because he should be given an opportunity to oppose it. Oppose it.
But I am giving the.
But the order can be passed after the period also because I had a personal experience, Ravindran, there was judgment was placed, Ravindran. And this, I think, judgment that
How, what will be depend of this gap period? Was it legal or illegal intent? But I am giving chronological judgment one after another.
no, in that Ravindran judgment, it has been said that it is the duty of the IO to file it before the expiry of the period, of course. But the order can be passed subsequently also, and probably it will be from that date, from the date of expiry. So I have to check up the judgment because in NI I always used to have this problem that they file it in the last 2-3 days and a lot of hurry to complete. Then this was shown very fairly by one of the counsel for the accused only that this can be done. You have the flexibility.
But I take.
So I learned that.
Jayananda Prasad, my lord, first judgment. My lord Vijay Agarwal. Para 6, my lord, kindly. Para 6. He has relied Sanjay Kumar Kedia of incident of the narcotics. The Honorable Supreme Court was called to examine the preconditions required for extension of statutory period of detention. After adverting the relevant law, Apex Court has called out the precondition of extension of detention period in the following way. The maximum period of 90 days fixed under section 1672 of the code has increased to 180 days for several categories of the offences under that, but the proviso authorizes a yet further period of detention which may in total go up to 1 year, provided the stringent conditions provided therein are satisfied and are complied with the conditions provided are. A report of public prosecutor, that your lordship says this, which indicates the progress of the investigation, specific compelling reason for seeking the detention of the accused beyond the period of 80 days after notice to the accused. After notice to the accused. It is from the Sanjay Kumar Kedia of the Indian media. In this case, no notice of the accused was given. My 364 petition was filed by the IO pro 50, but there was no progress report of the investigation. Only mentioned that we could not complete the investigation because of for want of all these things. And one co-case is also arrested. Then my so much in this Vijayawada justice said that he must be heard, he must be given the opportunity to, he should be informed. In this case, nothing was done. That's why my Lord Justice Vijayawada has watched the proceeding and he has also given that a register is directed to forward the copy of the order of the Director General of Police Assam Gauhati. He is further directed circulates the order to all the police stations and advisory notes to the investigating officer. In view of the legal position laid down the Supreme Court discussing the orders, I am constrained to accept the bail charge. Consequently, the learned special judge Dubri is directed to release the accused person furnishing a bail bond of 40,000. Since the three conditions were not fulfilled, that's why it was bail petition was directed to release on bail. Gentlemen, I take your lordship next judgment, that is Honorable Madras High Court, that is Judicial Madras Sundar Mohan Malik, Honorable Justice. It is Muhammad Azhar Singh Malik. Here, you will find in Malik, clause 4 of the judgment Malik. Clause 4, kindly come to clause 4, page 25, kindly page 25 of the inner page of the 25 of the judgment Malik. Clause 4, the trial court shall also consider the extension of application as expeditiously as possible and not later than 7 days. Here, 13 days. From making such application.
The High Court,
The Calcutta High Court, as stated earlier and observed by the Calcutta High Court, if the notice to the accused of in the extension application is to make accused aware of filing of the extension application, and that is being considered, and therefore there is no need to grant unnecessary adjournment on the request of the accused. In this case, there was no notice to the accused. Then, right.
Yes, I've seen this. High Court court is at least when it is the Calcutta High Court has said, Madras High Court, that few are desirable before 14 days. But sometimes they are not sure. No? At the time they may be expecting to file the final report, but it at the last moment it's not ready. So sometimes it can take.
Police can be directed to file extension application well in advance at least 14 days before the expiry of the statutory period. If further detention of the accused is necessary for the investigation of the case,
Just persuasive value.
along with the report to the public prosecutor.
That is more important. This is persuasive value.
It is like our case.
That I'll see. Public prosecutor report is essential. That is true. That is the basic law.
The extension application filed within 14 days before the expiry of the.
No, that is a Calcutta High Court actually. We are not bound by that. It's Calcutta High Court, persuasive.
Yes.
But desirable within 14 days. It should not be later than that.
Third case, Punjab and Haryana High Court. Here you will find in inner page. Inner page 6, kindly 6, my lord.
Yes.
Provided that if it is not possible to complete the investigation within a safe period of 180 days, the special court may extend the safe period up to 1 year or the report of the public prosecutor indicating the progress of the investigation is lacking. The specific reason for the detention of the accused beyond the safe period. Then, my lord, I take your lordship. The legislative intent is to amply clear in so far as the option for seeking the extension of time has not been left into the investigation agency. The relevant provision categorically provide that court may grant extension of time, but only on report of the public prosecutor. In this regard, reference may be made to the observation of the Honorable Supreme Court in Hitendra Vishnu Thakur. Your lordship will get it.
It has come from there only.
Yes, it
Yeah,
was-
now I remember.
Yeah.
Ravindran is taken from the Hitendra Vishnu Thakur, which was in the context of Tada.
Yes.
But the
yes,
same
it
thing
was-
was, same thing was applied with regard to this UAP, I think, in Ravindran. Anyway, that's okay. This will have.
That the investigator must be completed to the output promptitude, but where it becomes necessary to seek some more time for completion of the investigation, the investigating agency must submit itself to the scrutiny of the public prosecutor in first instance and testifying about the progress of the investigation and parties' reason for seeking further custody of the accused. A public prosecutor is an important officer of the state government and is appointed by the state under the code of the criminal procedure. He is not a part of the investigation agency.
Yes, I'll go through it.
Then, madam, I think the law, the another judge of Punjab, Haryana High Court, Ravinder versus State of Haryana. Ravinder. That your lordship has given difference after your book. Here I take your lordship on the inner page, 5.
Right.
The first condition of the report of the public prosecutor suggests or
Uh,
indicates
wh-
regarding,
wh- which paragraph?
paragraph, my lord, page 5. Page 5.
First.
Prosecutor of indicating the progress of the investigation and the specific reason for detention of the accused beyond the said period of 180 days. Then, lastly, first condition is the report of the public prosecutor suggests or indicates regarding the progress of the investigation. And the second condition, think one on, is that specific reason for detention of the accused beyond period 180 days. These two conditions are coexistent and non-satisfaction of even one condition will not give any entitlement of the prosecution for seeking an extension of 180 days. The language used in the provider is absolutely unambiguous and clear and has to be given a literal construction. Otherwise, also grant or non-grant of default bail is a different pedestal as compared to grant or non-grant of the regular bail under section 439 of the Code of Criminal Procedure. The grant of bail under section 1672 is statutory and indivisible right. The present case falling under NDPS Act and therefore the period of extension under section 36 of NDPS Act, and for the purpose of this present case, the period of 180 days can be extended by virtue of the section 4 of section 36A and the for a further period of 1 year, but subject to the conditions specified under the provision which are contained in the proviso subsection 4 of section 36 and it is Act. So, my lord, here also, your lordship will find that court has constrained to grant the bail to the petitioner.
In this case, the report of the public prosecutor was not there.
On the applicable, I will show you.
Application by the IO.
And, my lord, our own High Court, my lord Justice Kolita, here also, that is my judgment of TG Lina versus Union of India. Here also, reference of Hitler Desai and other aspects have been given. Bail application was rejected by the court because of the fact that extension, the fact that paragraph 10, this court has seen that while filing the instant bail application, it was not pleaded case of the accused applicant that there is a violation of section 36 of the NDPS Act. It is further saying that the order dated 27/10/25, whereby the last district section judge comes special judge Kachar, teacher, extending the time of period of 3 months, that is 90 days, in terms 36A, has not been challenged as assigned. So, my lord, that's why when our bail petition was still pending, now that we have assigned before your lordship by challenging that
Extension.
That's why we have come, my lord.
And the bail application is connected is
This case.
yeah.
Now,
If the extension is not upheld, then automatically he'll get default bail.
Yes. Now regarding bail petition, my lord, I am submitting, my lord. There is, my lord, one thing your lordship to consider, after getting extended 180 days also, they have not been able to file the
office report.
Hmm.
As a result, he behind the bar 446 days to wait, and no trial has started, no charge was framed,
Hmm.
and question of evidence is far away. Then, my lord, in this case, we have applied for the copy of the 36, 47, 48, but we could not get the certified copy as it was not available in the record.
Hmm.
So, record has been called for. Your lordship is to carry whether 37, 36, 47, 48 has been complied with or not.
Okay.
We have raised this question with the trial court also.
Hmm.
Trial court has immediate our prayer, my lord, but rejected our bail petition without
Hmm.
discussing these three
Hmm.
materials.
Hmm.
And regarding extension also. So, my lord, your lordship, the out and out this extension was illegal, and no accused was not heard, no intimation was given to the accused, and no progress report of the investigation was submitted while petition was filed for extension. I am showing the petition. Just 1 minute. Wait. Hello, I take you kindly peruse page 56 of my BA.
Hmm.
So in the court of the Honorable Second Judge, Tachar.
This is the application.
Yes, it is more desperately submitted that the above mentioned case has been registered in NCB Gauhati by trial number certain that these accused persons are in judicial custody from 7/4/25 as I submitted it.
Hmm.
Investigation is being progressed of carried out, and accordingly the provisions of the law that as per the 36A, 36 A, the A NDPS Act, the stipulated period of completing the investigation of 180 days from the date of arrest of the accused person, the said period is going to expire on 3/10/25.
Hmm.
This investigation could not be completed within the prescribed period due to the following reason. What is that? Chemical analysis report of the seized drugs from the CRCL, New Delhi.
Hmm.
Efforts are being underway to trace the apprehended the co-accused,
Hmm.
supplier, receiver, and trafficker. The verification of call details record, bank transaction, and interstate link is pending. The huge quantity of drugs has been seized, which commercial quantity and accused may not be granted bail, as otherwise further investigation of the case shall be hampered. The investigation is at a crucial stage, but the time is genuinely required to complete the investigation.
This application was filed by the IO
IO. Through PP.
through PP.
Yeah.
PP is this R Bhattacharya.
Yes.
He is the PP.
His signature is also there.
Then it's application has to be filed by the IO through PP. Through PP. No, actually there will be the report of the PP is
It is
necessary.
not there.
Report of the PP is necessary.
Yeah.
The IO files the application before the PP,
Yes.
and the PP
PPF
submits
files.
before the court. Submits before the court.
I-
PP submits before the court after giving along with his report.
Yes.
Along with his report.
Report is not there.
Hmm.
Report is not.
Hmm.
Only said that because of his reason we could not complete the investigation.
It is filed by the IO through the PP. Hmm.
So, my lord, out and out, it is clear that provision law has not followed. And the crucial question is that after the extension of 180 days, they have consumed another 250 days, 250 days. But till today, position is safe.
Hmm.
Can they get this extended period
Hmm.
automatically?
Hmm. Okay. I'll come to you. No.
Lordship, as my senior has.
Common submissions on the bail and this common submissions.
Yes, yes, yes.
No need.
As my senior has indicated, Lordship, application as it is apparent from the record was filed on the 3rd of October. And that was it is reflected in the order. If I may take your Lordship to page 16, the order of the learned trial court, that is in criminal petition 88,
Page.
page 16, Annex 1.
Hmm. Okay.
Today is fixed for order on petition 1257/18 filed by the complainant MVPS through learned special PP for extension of time. Yes, an application of the IO that has been placed through the learned public prosecutor. And if your Lordship will come below the last paragraph of the same page, the present petition was filed on 3/10/2025, where this order was passed later on, Lordship. This order was passed 16/10/25, if I'm not wrong. It appears 16/10. This petition was filed on 3/10/25, that is on the 179th day from the date of arrest before completion of the statutory period of 180 days. Now, if the submissions made by my senior that after this petition was of course allowed and the prosecution was given another 180 days. Now my senior submits that even after completion of that 180 days, the final complaint is yet to be submitted. If that be so, Lordship, a challenge to this order at this stage is of no consequence because ultimately after
The extended statutory period is also over.
that is also over.
That was I was thinking.
Therefore, my humble submission before your Lordship at this stage would be, Lordship will get the updated status. If we have not submitted any application, definitely he has to be granted bail if it is not completed. But then challenge to this order now is of no consequence. That is my humble
But
submission.
another thing is that, as we know, it is actually already well settled. The report of the public, whether it's all these extension work,
that-
UAPA, commercial quantity,
That
the
would be,
report of the public prosecutor is necessary.
that would
actually.
be matter of my humble submission would be that would be a matter of interpretation because
I think it is well settled,
yeah, that I
The report of the public prosecutor is necessary.
because the public prosecutor will get the
Sufficiency of the report is another matter, of course.
because the public prosecutor will be getting the materials from the IO.
Yes.
He cannot make a report out on his own.
He has to, that is the actual procedure. The IO
Now-
requests the public prosecutor with his application.
yes,
Public prosecutor peruses these grounds, the materials, progress of investigation. Then if he is satisfied, makes a
Now-
ideally.
Yes.
That's the
So,
process.
Lordship has to see whether
And
there was
see-
any material for granting any extension. Now, that material has been provided by the IO. It is another thing that the application was made by the IO and submitted through the public prosecutor, but the materials are there. But the materials are there. It is reflected in the order, Lordship, in the page 16. It is reflected there. But still, since the extended period is also over, whether a challenge to that order will be of any consequence now. And if your Lordship has to pass any order, Lordship will have to first be satisfied what is the status as of now. That would be my humble submission, Lordship.
Let's see.
My lord, regarding status, my lord, was it not their duty to produce during the court? No. We have already submitted. Now they are shifting the burden to us.
No, the objection has been filed.
I have filed
Detailed
an
objection.
But objection also, they need not reflect that we have submitted the offense report. There is nothing.
So
The-
probably
it
investigation
is-
is going on.
It is,
Still investigation going on.
it is not, there is not a single averment in the petition that after 180 days, 200 and some days have also passed, because lordship will see from the orders. My friend has referred this application long back, but due to clerical errors, this petition could not be taken up. This is only for the first time that lordship is hearing the matter on record.
Well, my bail petition is pending since 25.
It
225.
it is the same thing, lordship. The bail.
They have never raised in the bail petition that, no, we have filed it
The
twice.
problem arose because of the tagging actually.
Yes.
Separately, it could have been seen. That should have been seen actually. Could have been seen.
There is no scope to oppose this petition in any angle.
I'll see, hopefully.
Yes,
Okay.
sir.
No, enough.
Lordship will pass appropriately.
And- That's many case laws were there on this extension, especially on UAPA. But now I've forgotten. I have to
Sorry,
get back. No, Ravindran was a good judgment and this also.
How ballot your lottery you want? We should have a happy holiday.
I think